I understand the intricacies of water as a utility, and I appreciate your efforts in making sure that we preserve this precious natural resource. I look forward to working with many of you in the upcoming months and during the upcoming session, and if we can ever be assistance to you here in Cameron County, please do not hesitate to call on us. Thank you, and God bless you and the work that you do on behalf of our great state. Welcome.
Thank you, Judge Trevino. Thank you. We also have City Commissioner Ben Neese. Thank you for attending as well. I look forward to going through some discussions this morning, starting with the 1944 treaty. We have some folks from the International Water Boundary Commission, and then we have some of the irrigators that want to discuss some of the issues that have occurred over the last 3 decades within that treaty. We also are going to be talking about interim charges dealing with the expedited CCN decertification process, and then also we're going to be discussing the fair share bill that Representative Burns has. So I want to introduce the members of the committee. They have traveled a long ways to get here, and I got a little business last week in a roast because of that. But we got Representative Burns from Cleburne, Representative Frank from Wichita Falls. We have Tracy King from Uvalde, Representative Ashby from Lufkin, and we have Pancho Navarez from Eagle Pass, and then our host, Eddie Lucio. So
thank you, Mr. Chairman.
All of you, thank you very much for attending. If you want to testify, there's witness affirmation forms that you can fill out and give them to the clerk down there, and we'll make sure that we have that information. We have to have all that information in place, whether it be invited testimony or public testimony. So we're going to jump right into the first charge. The chair recognizes Sally Speener with the International Boundary and Water Commission. Sally, if you'd come up. Yeah. You can sit or stand, either one, whatever you prefer. And Sally, you traveled in from El Paso?
I did.
Okay. Well, thank you for coming all that way.
It's always nice to come down here and get a dose of green after being in the El Paso desert.
Yeah, there you go. Just state your name and who you represent for the record.
Chairman Larson, members of the committee, my name is Sally Speener, and I'm the United States Secretary of the International Boundary and Water Commission, United States and Mexico. In my role, should I continue?
Please.
Okay, very good. In my role, I provide foreign policy guidance to the U.S. Commissioner, manage the U.S. section's communications with the Mexican government, and oversee the foreign affairs and public affairs functions, among other responsibilities. I've been involved in matters related to application of the 1944 Water Treaty for over a decade.
Okay, can you step up a little bit closer to that mic, if you don't mind? Just so.
The International Boundary and Water Commission, is that better?
Yeah, that's fine.
I guess I could lean in a little more. The International Boundary and Water Commission, or IBWC, traces its history to 1889, when the two governments established a permanent commission to resolve boundary disputes that occurred due to shifts in the channels of the boundary rivers. Decades later, the treaty relating to the utilization of waters of the Colorado and Tijuana rivers and of the Rio Grande, known as the 1944 Water Treaty, greatly expanded the role of the Commission, granting it authority to distribute the waters of the boundary rivers between the two countries and to address border sanitation problems. The treaty established the modern structure and mission of the IBWC, which is to apply the boundary and water treaties between the United States and Mexico and to settle differences that arise in the application of the treaties. The IBWC has two sections, a United States section, or U.S. IBWC, and the Mexican section. The U.S. section is an independent federal commission, and we receive foreign policy guidance from the U.S. Department of State. The IBWC is both an engineering and a diplomatic agency. We seek both technical and diplomatic solutions to boundary and water issues. Current responsibilities of the Commission include determination and accounting for the national ownership of waters, operation and maintenance of international dams, including Falcon and Amistad Dam, and Rio Grande flood control, among many others. The upper portion of the international Rio Grande Basin is regulated by the Convention of 1906. Under this treaty, the United States annually delivers 60,000 acre-feet of Rio Grande water to Mexico at Ciudad Juarez, Chihuahua, which is across the border from El Paso, except in the event of extraordinary drought. There have been numerous drought-related reductions over the decades, including this year, when Mexico received 63% of a full allocation. The lower portion of the Rio Grande, starting at Fort Quitman, Texas, which is about 90 miles downstream from El Paso and continues on to the Gulf of Mexico, is covered by the 1944 Water Treaty. In this part of the basin, most of the river's flow originates in Mexico. Water for both countries is stored in the two international reservoirs constructed as part of the 1944 treaty, Amistad Dam near Del Rio and Falcon Dam near Falcon Heights. The treaty allots to the United States 1/3 of the flow arriving in the Rio Grande from 6 Mexican tributaries. The treaty also indicates this third shall not be less as an average amount in cycles of 5 consecutive years than 350,000 acre-feet annually. Based on this treaty provision, we commonly refer to this as the 5-year cycle. In the event of extraordinary drought, whereby Mexico does not deliver the full volume of 1.75 million acre-feet over 5 years, then Mexico must make up any shortfall in the next 5-year cycle. However, there's an exception to this. If the U.S. conservation capacity is filled at the 2 reservoirs, then all debts are canceled and a new cycle begins. Since water accounting began under the 1944 Water Treaty, 4 cycles, or 12%, have ended with a water debt, while 25 cycles have ended early because the U.S. capacity in the international reservoirs was full and the United States could no longer store the water. The last cycle to end with a debt was the last one, the October 25th, 2010 through October 24th, 2015 cycle. As you'll recall, this period included the drought of 2011, the driest year in Texas since 1789. Mexico paid off the debt in January 2016 through arrangements of the International Boundary and Water Commission. The last cycle to end early was the July 13th, 2010 through October 24th, 2010 cycle. And Representative Lucio, I'm sure you remember that well because that was when we had some hurricane and tropical storm activity that caused widespread flooding throughout the valley. The current 5-year cycle began on October 25th, 2015. Mexico delivered 482,000 acre-feet in year 1, of which 263,000 acre-feet was credited to the previous cycle's debt and 219,000 acre-feet to the current cycle. In year 2, 565,000 acre-feet, and for year 3, 173,000 acre-feet as of September 22nd, 2018. The year 2 volume reflects proactive steps to increase deliveries so there would be no shortfall at the end of that water delivery year. Because of the abundant deliveries in year 2, we were ahead of the seasonally adjusted minimum annual average over the last year. Deliveries leveled off during a hot, dry period in late summer, but are picking up again with recent precipitation in the basin. What this means is that Mexico has been up to date in its 5-year cycle deliveries to the United States and is meeting the minimum annual average specified in the treaty. Because of recent wet conditions, we're seeing Mexican reservoirs filling, and we're likely to see increased deliveries from Mexico's tributaries in the immediate future, as often occurs at this time of the year. Although there's not currently a water debt, we remain concerned about the unpredictability of Mexico's Rio Grande water deliveries to the United States, which during years of low reservoir storage can present significant challenges to farmers and cities who rely on this water. We've been engaged in efforts to address this concern. Notably, in April 2017, officials from the International Boundary and Water Commission, United States and Mexico, met at the Texas state capitol with representatives from Mexico's National Water Commission and the state of Texas. At that meeting, we agreed to form a binational Rio Grande hydrology work group. The United States representatives expressed their goal for the hydrology work group to be a vehicle for increased transparency regarding basin operations and to use riverware modeling as a tool for basin management. By applying science and engineering expertise, we believe this effort can provide water managers with the tools needed to improve the predictability and reliability of Mexico's Rio Grande water deliveries to users in both countries. In that fashion, we believe we can increase the likelihood of receiving a minimum of 350,000 acre-feet per year as an annual target, reducing the high level of variability and unpredictability that often characterizes the deliveries. Since then, this binational hydrology work group has met regularly in person and via webinar. It's developed a binational comprehensive base model using riverware that incorporates infrastructure, historical records, and current system operations. The U.S. members of the hydrology work group include modelers from the Texas Water Development Board and the Texas Commission on Environmental Quality. In the near future, we expect this model to be ready to begin running water delivery scenarios, which consider proposed management strategies or policies under an array of hydrological conditions. That way, we'll be able to see how diverse scenarios would perform in providing equitable shares of water to U.S. and Mexican users based on historical data incorporated into the model. With these modeling results, our separate policy work group, which also includes participation from the state of Texas, and Representative Larson, you and Representative Workman have both participated in some of those meetings in the past. The policy work group will be able to develop policy recommendations that could be implemented to improve the predictability and reliability of water deliveries to users in both countries. So to summarize, Mexico is currently up to date in its Rio Grande water deliveries to the United States under the 1944 Water Treaty, and we are working cooperatively with Mexico and the state of Texas to develop the technical tools that will enable us to make informed policy decisions to better manage water deliveries to users in the United States and Mexico. Thank you very much for your attention, and at the appropriate time, I'd be happy to respond to questions.
Yes, thank you, Sally. Chairman Lucio?
Well, Commissioner, I haven't had a chance to formally meet you, so congratulations.
I'm actually the secretary.
Or secretary,
Yeah,
excuse me.
we have a new commissioner
Yeah.
who was just appointed by President Trump. Her name is Jane Harkins, and she will be reporting towards the end of October.
Okay.
And be sworn in.
Madam Secretary, it's nice to see you. Well, first, Lyle, thank you for coming down here. You have traveled the state. I think we've had a diverse experience everywhere but Austin. That's where we should be, outside of Austin during the interim. To all my friends and stakeholders from every group here in South Texas, thank you for being engaged. Sixth session on the Natural Resources Committee, and we've been able to meaningfully participate because our local stakeholders inform us on their issues. That being said, I have at various times over the last 12 years been intimately engaged with former commissioners and former TCEQ commissioners as well, going to DC, going to Mexico to have these conversations. I think there is some lingering frustration with our stakeholders because we don't have predictability. I like some of the innovative, I guess, discussions that are taking place in the work groups. I would love to re-engage. There was a time, I guess, I got a little frustrated and kind of took a step back and worked on other water issues, but I would love to re-engage. I think ultimately where we would want to be, we can talk about how technically we can amend the treaty and all the other very heavy lifting things we could do, but I think ultimately if we could get Mexico to treat us as a water user and prepare for allocations every year like they do all their other water users, we would be much better off. So what we've seen historically is they get bailed out by a natural event that fills up reservoirs, and then they're like, you see, we were good stewards, we meant to deliver that. And the economic consequences of that to our farmers, because we still are an agricultural region, are dire. So please allow us an opportunity, and there's some gentlemen in this room and ladies in this room that know that treaty and know the history of those deliveries and the interactions and discussion with Mexico. they've forgotten more about it than I've ever learned. So there's some valuable resources behind you that I would love to introduce and engage with the commission.
Thank you, Representative Lucio. And I think we have shared that frustration over the years, and I think the effort that we're currently working on, as well as some work that's underway domestically with basin management within Mexico, we believe is going to get us closer to that. There's an annual allocation to the United States. And I remember even years ago, some of the irrigation district managers down in the valley saying, even if we're not going to get a full allocation this year, just tell us how much we're going to get.
Yeah.
So that we know. And so I think we're on the path, at least for that part of it, and hopefully much better planning to try to move towards a 350,000 acre-foot annual target and to have equitable water resources sharing between the two countries on an annual basis, not just a 5-year basis.
Thank you so much.
Anybody else have any questions? I just want to bring up that other river that's in the 44 treaty. I've attended the Colorado River Water Users Association meeting for the last 6 years. People from Mexico are there. We're 100% compliant on releasing 1.5 million acre feet of water that originates in the United States into Mexico. And we don't have a 5-year shore up on that. It's on an annual basis, and we deliver it. We release water from our dams into Mexico, into the richest agricultural region of Mexico. But for whatever reason, they don't have the same approach. The reciprocity doesn't happen on an annual basis. The timing of the releases also are critical. As the Rio Grande Valley farmers are planting and they need the water, a lot of times the water's not there. And so I'm glad that they're compliant right now. The problem is we need to look at the future. Minute 323 didn't even discuss the Rio Grande, and I made several attempts to try to put the Rio Grande into that minute. And as we go forward, we have to sink those rivers. There's absolutely no reason that the U.S. government deals with the Colorado River water that comes out of Utah and Wyoming and releases it, and then to the detriment of the lower basin states in the Colorado, where those 3 states are spending billions of dollars a project to supplant the water that we're releasing. And then on this side, we look the other way. And the releases are untimely. They're not happening in the springtime when we need them. Also, they're inconsistent. And like Chairman Lucio said, the problem is that when a natural occurrence like a hurricane or a typhoon happens, they fill our reservoirs. And I said in those meetings, so frustrated, you had 84, in the Rio Conchos, you had an 84% capacity sitting in their lakes, and they weren't releasing. And to the detriment of all the farmers down in the Rio Grande Valley, Eagle Pass, Del Rio, all of those areas are the economic issues that they had to deal with because they had the water. The difference is the federal government controls the water in the Bureau of Reclamation and releasing water. They are controlled by state governments and irrigation districts in Mexico, and so they're trying to reconcile issues. I don't see it as a valid international treaty if we're compliant and they're not. And so somewhere as we start the whole issue of the next minute and we amend that treaty, the only way that we're going to get it into perpetuity is to sink those rivers. And we don't release if they don't release. It's that simple. And I think the spirit of the people that put the treaty together in 1944, that's what they meant. So you have a bad actor, the other country doesn't release water. But we don't treat it like that. And that is the most frustrating aspect of this whole dialogue as we continue to bifurcate the whole discussion. So I don't know where we get there, but I definitely would like to have that issue discussed in any future attempts to amend that treaty.
I appreciate your comment, Representative Larson, and I know you've shared this perspective with us before. The treaty provisions for the Rio Grande and the Colorado River, as you know, are different, and the treaty doesn't have that explicit linkage that you're seeking. There are different provisions for each river. The treaty has an annual delivery requirement on the Colorado River, and it's a 5-year cycle requirement for the Rio Grande, which of course is affected by tropical weather, as we've already mentioned here, and has much greater flow variability. The Colorado River is a very complex system. As you know, it's a lot of different states involved. The Bureau of Reclamation and Department of the Interior have an annual plan, and there are other requirements in the treaty that are different from what we have in the Rio Grande. But I think what we're trying to do, if not an explicit linkage, but have management tools that help us provide that more predictability on an annual basis than we have in the past. So I think we're getting there without that explicit linkage that you're seeing, but I think we're making progress.
Yeah, I think that's in the era of looking at all international treaties worldwide, and only in dealing with the ones that are not good for the United States, this should be Exhibit A. Because we've got the State Department going all over the world looking at tariffs and looking at a lot of issues that obstruct our economy from growing. This one has more of an impact on Americans on a daily basis than any of those treaties. And that's why that linkage needs to take place. So I would suggest that the State Department and the International Boundary Water Commission, we push forward, because when you're gone and the folks that take your place are gone, we're going to still have the issue where Mexico won't release, because they look at it as a subjective approach. Then our approach is we're always releasing. You know, Lake Mead's at all-time low elevations, and those 7 states, that they bleed because of trying to comply with the treaty. So I appreciate everything y'all are doing, the technology, but ultimately Mexico's going to release the water when they want to, and the only way we're going to get them to comply is make them comply, or we're not releasing water into their country.
And ultimately, Representative Larson, where we think this is headed, or certainly what we're advocating for, is to have a Rio Grande minute, as you had mentioned. And I didn't include this in my testimony, but for those of you who are not familiar with our commission, a minute is a binding agreement of the United States and Mexico. It's considered an implementing agreement of the treaty. And so I think our ultimate goal is to have the modeling work, run scenarios, come up with some management tools that work for both countries and provide increased transparency, reliability, and predictability, and adopt that in a minute in the future.
Sally, thank you,
Thank you.
for your involvement in this for a number of years, and we appreciate all the work you're doing with the hydrology groups. So thank you.
Thank you, Chairman. Thank you, members.
Chair recognizes Sonny Hinojosa and Wayne Halbert with the Texas Irrigation Council. I'll just state your name and the organization you're working with. And Sonny, you go first.
Yes, sir.
Okay, sounds great. Y'all can sit here if you want to, whatever.
Chairman Larson, members of the committee, thank you so much. Good morning. It's a pleasure to testify to you this morning on behalf of the Texas Irrigation Council. I'm Sonny Hinojosa, and in conjunction with Wayne Halbert, we will discuss the 44 Treaty and how it affects the Lower Rio Grande. As Sally mentioned, we do utilize the Treaty of 44. It's the utilization of waters of the Colorado, as you mentioned, and the Tijuana rivers and of the Rio Grande. This treaty is otherwise referred to as the 1944 Treaty. This treaty distributes the waters of the Rio Grande between Fort Quitman, Texas, and the Gulf of Mexico. The Rio Grande part is under Section 2, Article 4 of the treaty, and it states that the waters of the Rio Grande between Fort Quitman, Texas, and the Gulf of Mexico are hereby allotted to the two countries in the following manner. To Mexico, all of the waters reaching the main channel of the Rio Grande from the San Juan and Alamo rivers, the lower part of the river, below Falcon Dam, and also the return flows from the lands irrigated from those two rivers. Mexico also gets 1/2 of the flow in the main channel of the river below the lowermost international storage dam, which is Falcon, and the said flow is not specifically allotted under the treaty from any other tributary. 2/3 of the flow reaching the main channel of the Rio Grande from the Conchos, the San Rodrigo, San Diego, Escondido, and Salado rivers, and the Las Vacas Arroyo. Mexico also gets one half of the other flows not otherwise allotted by this article occurring in the main channel of the Rio Grande between Fort Quitman and Falcon Dam. To the U.S., we get all the waters reaching the main channel of the Rio Grande from the Pecos, the Devils, the Good Enough Springs, Alamito and Terlingua Creeks, and San Felipe and Pinto Creeks. U.S. also gets the other half of the flow in the main channel below Falcon Dam that is not otherwise specifically allotted under this treaty to either country. The U.S. also gets 1/3 of the flows reaching the main channel of the Rio Grande, once again from the Conchos, the San Diego, San Rodrigo, Escondido, and Salado rivers, and the Las Vacas Arroyo, provided that this 1/3 should not be less as an average amount in cycles of 5 consecutive years than 350,000 acre-feet annually. The U.S. also gets the other half of the flows not otherwise allotted by this treaty between Fort Quitman and Falcon Reservoir. The treaty goes on to read that in the event of extraordinary drought or serious accident to the hydraulic systems on the measured Mexican tributaries, making it difficult for Mexico to make available the runoff of 350,000 acre-feet allotted in subparagraph C of paragraph B of this article to the U.S. as a minimum contribution from the aforesaid Mexican tributaries. Those 6 tributaries under subparagraph C of paragraph B are once again the Conchos, San Diego, San Rodrigo, Escondido, Salado rivers, and the Las Vacas Arroyo. These are the 6 named tributaries in which Mexico gets credit to delivering water to the United States. Any deficiencies existing at the end of the aforesaid 5-year cycle shall be made up in the following 5-year cycle with water from the said measured tributaries. This is minute 234. As Sally mentioned, there are minutes for the treaty, and in case Mexico is deficient in their deliveries of 1.75 million acre-feet in a 5-year cycle, the Commission came up with minute 234, and it states that the waters of the Rio Grande allotted to the United States from the Concho, San Diego, San Rodrigo, Escondido, and Salado rivers, and the Las Vacas Arroyo, the Commission met in 1969 to consider the matter of complying with the provisions of the Article 4 of the treaty, once again relating to the waters of the Rio Grande allotted to the U.S. from those 6 named treaty tributaries. Any deficiencies occurring in a cycle of 5 consecutive years in the minimum contributions of 350,000 acre-feet of Rio Grande water allotted annually as an average to the U.S. from the said tributaries. I keep referring to the said tributaries because that's where the U.S. is supposed to get their water from Mexico, those 6 said tributaries. This is a report from the IBWC of the cycle that ended in 2015. This cycle commenced October 25th of 2010, ended October 24th of 2015. The 6 named tributaries contributed 1,236,557 acre-feet. There were some account adjustment credits in which 65,857 acre-feet were credited to Mexico, and the Rio San Juan was also credited for 184,340 acre-feet. The total delivery on that 5-year cycle was 1,486,753 acre-feet, which is shy of the required 1,750,000 acre-feet. The IBWC had a balance of 250 acre-feet that would carry into the next cycle for payment. However, the flows from the Rio San Juan should not have been credited towards that treaty delivery. We questioned IBWC about this, and they respond that the U.S. can use this water under Article 9, subparagraph E. Paragraph E reads that the Commission shall have the power to authorize temporary diversion and use by one country of water belonging to the other when the latter does not need it or is unable to use it, provided that such authorizations or the use of such water shall not establish any right to continue to divert it. And that is true. the U.S. can use Mexican water, but nowhere in this article, nowhere in any other article in the treaty or the minute does it state that Mexico should get credit for this water from the San Juan. In summary, the federal issues that have surfaced is, yes, the U.S. can divert and use Mexico's water under Article 9, Paragraph E of the 44 Treaty. However, to give Mexico credit for the use of these flows from other than the said or 6 named tributaries is inconsistent with the 44 Treaty. On the state level, the TCQ Rio Grande Water Master, in an effort to treat the use of the Rio San Juan diversions, charged these diversions to the Rio Grande water right holders, the charger storage rights in the Amistad Falcon Reservoir system, trying to treat it as if it were one of the said tributaries. So what we've learned on the state level is to charge a water storage account in the Amistad Falcon Reservoir system when the water is not released from storage is inconsistent with Texas Administrative Code Title 30, Chapter 303, Operation of the Rio Grande. This concludes my portion of the testimony. I'd be glad to answer any questions.
Any members have any questions for Sonny? Chairman
Quick
Lucio.
question. Sonny, thank you for being here. A few folks up here were asking. So when water hits the reservoir and the reservoir rises to a certain level, based on treaty language, it is deemed that the water has been delivered or that Mexico is in compliance, regardless of the, so if a tropical storm moves through the valley from the East Coast, from the Gulf of Mexico, happens to sit over the reservoir for a little while, fill up the reservoir, at that point, Mexico's relieved of its obligation to deliver via the tributaries named in the treaty.
If the U.S. conservation fills,
Right.
yes, sir, in both
Okay.
reservoirs.
So it's not as if we have a meter that is sitting on those tributaries or that we see water pass through.
On these 6 named tributaries, we do.
What they do,
Yes, sir, they are
however,
measured.
but if the reservoir fills, it doesn't matter whether it came from there or it came from a storm.
That's correct. When
Right.
the U.S. share of conservation capacity fills,
Correct.
all debts are considered
debts.
paid. Yes, sir.
Okay.
Sonny, there was a report the Extension Service, Texas A&M, released about the economic impact to Rio Grande Valley over the last 2 decades, and it was the loss of about $343 million of loss to crop damaging because of drought, and just the in-stream flow of the Rio Grande was diminished, and it was directly related to Mexico not releasing several years in a row, and then waiting for a natural occurrence like a hurricane to come in to satisfy that. I think, and Sally, you've heard me say it before, why are we on a 5-year cycle and they're on a 1-year cycle from the Colorado? That has to change. And there's, for us to continue to allow this to happen while we're complying on that side, it just doesn't make sense. But I'd like for you to go into the impacts on an annual basis when the releases don't take place.
Yes, and that went back to the cycles from 1992 to 1997 and 97 to 02, when Mexico was deficient in their deliveries. In fact, they even started a 3rd cycle, which is unprecedented, not even called for in the treaty. But at that time, we were desperate for water, and we needed to know, our farmers needed to know in advance that we were going to have some water so they can make the investment of planting in the ground. There's no sense in making that expenditure if you know you're not going to have the water later on. So we needed a commitment at that time from Mexico, at least to know a minimum amount that we were going to be receiving, so our farmers can make that investment of putting seed in the ground, of working their soil, in anticipation of receiving some inflows.
Thank you, Sonny. I guess, Wayne, are you going to come up and make a presentation? Sorry that you have to use the mic like a game show host, but that's pretty much the only way we can get the sound projected.
No problem. We'll try. I'll probably speak loud enough for you to hear it anyway. But Sonny, I don't know how to. I'm not sure I know which ones of those to do. But I'll try to work on it here. I'll holler at you.
Yeah, Wayne, just state your name and who you represent.
Yes. My name is Wayne Halbert with the Texas Irrigation Council, and I've worked for many, many years as manager of the Harlingen Irrigation District. I'm retired now, but they keep calling me back for this sort of thing. So anyway, thank you, Chairman Larson, for coming down here and bringing your committee, and thank you, committee members and staff, for being here. You've heard testimony this morning now from IBWC that Mexico's in compliance, and you've heard a great testimony from Sonny about the 1944 treaty and what it means. And now I'm going to try to give you a few comments about the consequences of the practices that we have now currently in accepting Mexico's being in compliant in so many cases. As Sonny has pointed out, Mexico is obligated to deliver to the Rio Grande 350,000 acre-feet of water. But that's not all that they're obligated to deliver. They're obligated to deliver an additional 700,000 acre-feet of water to the Rio Grande that will be Mexico's water. And so on an annual basis, and I realize it's spread out over 5 years, but just for us here to understand, on an annual basis, we expect 1,050,000 acre-feet of water to reach the Rio Grande from these tributaries on a 5-year average. But anyway, on an annual basis, 1,050,000 acre-feet. Now, what's been happening currently, through the last couple of cycles? Well, first let me say this. For 50 more or less years, that's the way the treaty was satisfied. For 50 some odd years, Mexico delivered their 350,000 plus acre-feet of water, plus their 700,000 acre-feet of their own water into the river system, into the dam system. And that's how it worked for 50 some odd years. About 25 years or so ago, things began to change, mainly because Mexico had begun to develop the basins, in the Concho Basin especially, to where they needed to utilize more of their water than they didn't want to deliver to the U.S. Make no mistake, Mexico does not release water to satisfy the treaty. Don't let anybody tell you that they release water to satisfy the treaty. They only release water because they can't capture it. The treaty is secondary to them, or somewhere way down the line. They do not release water to satisfy the treaty. We get water in the system because they can't capture it. As a matter of fact, for the last several years, over the last several cycles.
Wayne, we've
Yes.
got Representative Barrs.
Can I just interrupt you right there? Can I just interrupt you right there?
I'm sorry.
I'm going to interrupt you right there.
Sure.
I know it's not, it's probably not polite, but I'm going to interrupt you right there. What does it matter? I'm talking about from a result-based standpoint. Let's assume that you're correct and you can read into the intention of why or when they release the water. What does it matter? If they're satisfying the treaty or because they can't capture it?
What does it matter?
Yeah, I'm talking about from a result standpoint. It matters from the standpoint of following the treaty, but that's a separate issue that needs to get fixed another way. But I'm talking about from a logistical and practical standpoint. What does it matter to harp on that?
Okay, I'm going to try to explain that. That was as we get on through more of my testimony.
Well, that's why I was correct in saying it was rude of me to interrupt you.
I understand. I understand completely, and that's fine. That's perfectly okay. But I think you'll understand why I said what I said when I get on further down in my testimony. But here in the 1990s, it became evident that Mexico was not delivering water like they used to deliver. And that continued on, and we began to fight, and I'm saying fight. We began to squabble. We began to negotiate. We began to meet with Mexican authorities as irrigation districts and individuals to try to negotiate with IBWC to get Mexico to release their water on schedule. That eventually, in the 1990s, when President Bush, then was Governor Bush, we went to him for support from the state because the state of Texas at that time, up till that point, was not involved in these negotiations. Governor Bush helped us at that time. Governor Bush helped us to get the state involved. Bob Houston, as many of y'all remember Bob Houston, he was the first person that Governor Bush appointed to do that work, negotiating with Mexico. As the state of Texas began to take more of the negotiations for the state, the districts began to step back and let the state of Texas do that, which was hopefully good, and sometimes maybe not so good. But anyway, that's how that all got started. Then as we move on into the 2000 era, we began to see more and more Mexico not releasing water for the terms of the treaty. Now here's where it gets to be frustrating for us. Many times during this last cycle, Mexico did not release water into the Rio Grande system, but held water in excess of 100% of their conservation storage. Some of their reservoirs had as much as 200% of conservation level in their reservoirs, but they still did not release for the U.S., and the U.S. needed the water. We needed our water. So in this last accounting period, Mexico was allowed to go that 5-year period without satisfying their terms of the treaty. And then they were given options of how to do that. They gave them credit for water that came out of the San Juan. Now proponents will say, well, you got that water, you got to use the water, so what's the point? Why are you concerned? You got to use the water. In the first place, for 50 years, we got to use that water because it was excess water from flood conditions at no charge to our water accounting and no credit to Mexico. So this is a total change in the amount of water that was available to the U.S. users, in that it gave credit to Mexico and it charged our accounts. So it's a total, complete loss on both sides for us as the users. And that's why it's important, if Mexico is allowed not to meet the terms of the treaty and not encouraged to make the U.S. a user, a water user, in their accounting process on an annual basis, then they can carry it on up to the last minute and then be allowed to take credit for these waters that are out of the San Juan or other tributaries. And also, they were allowed to take credit in Falcon and Amistad by transferring water that was already in Falcon and Amistad over to the U.S. accounts. Now, what does this really mean? This really means that theoretically, Mexico could satisfy their debt on a regular basis by doing these transfers and allowing water that used to be free to us to use that was excess waters downstream from Falcon and Amistad. Giving them credit for those waters robs the Rio Grande could theoretically rob the Rio Grande of the total 1,050,000 acre-feet of water a year, because every 1,000 acre-feet, every 100,000 acre-feet of water that Mexico gets credit for in other ways besides the treaty takes away 300,000 acre-feet of water from the Rio Grande system. If Mexico is allowed to satisfy their 350,000 acre-foot obligation in other ways besides the treaty, that means the Rio Grande does without 1,050,000 acre-feet of water a year. The Rio Grande is the economic lifeblood to more than 500,000 acres of cropland in the Rio Grande system, in the Rio Grande Valley region, and drinking water to over 1,750,000 people. So the Rio Grande is important for the Rio Grande Valley region and for much of the region below the dams. The Rio Grande system is really at risk here. We urge the committee to recommend to return to the original intentions of the 1944 treaty with strict interpretations by the International Boundary and Water Commission and support for strict interpretations from the state of Texas. I thank you for the opportunity to speak, and I'll be glad to answer any questions.
Members, Chairman
Just
Lucio?
one important takeaway. So if we give credit to Mexico for non-tributary deliveries from other tributaries that are sometimes located below our reservoirs, we're essentially robbing ourselves of water that we would have received anyway and getting far less water, not getting the water that is required to be delivered via the treaty, right? So if, there's been this consensus where we say, okay, well, through that tributary, X amount of water was delivered to the Rio Grande. We're going to give you credit for that. But what I'm hearing from you and taking away from your testimony is that when we do that, we're robbing ourselves of significant water that we would have otherwise received anyway.
That's correct.
Okay.
We always receive that water that they're giving them credit for now.
Okay.
We always received that in the past.
I don't think I've ever heard you put it that way,
Yeah.
so that
Everything below
significant.
Falcon, if it's below Falcon, if it comes into the river below Falcon, if it's not utilized, it goes to the Gulf. And so it was allowed for both countries to pick up that water. There was always consent from Mexico or consent from the U.S. to do so, but both countries, we've always been able to utilize those waters. So now they're giving credit for those, and that means 3 times that much water does not come into the system above the dams.
Well, not only that, right, but all the tributaries that are named in the treaty are above the dam.
Above the dams.
So we can
All
capture,
the treaties.
so we can capture that, right?
Right.
The ones that we've been giving them credit for on occasion are below the dam, so we immediately have to put them to use or we lose them to the Gulf.
Absolutely. Absolutely.
Anybody else have any? Yes, Representative Frank?
Mine, I should ask questions because I'm 14 miles from the Red River border with Oklahoma, but
The other side.
who is it that is making those decisions and interpretations? It's the international, you mentioned it, but
That's
who
all.
is-
State Department.
International Boundary and Water Commission is the ones that make that decision. That's a binational commission,
And so those are appointed by.
Mexico and the U.S.,
So
yes.
Mexico appoints some of the members and then the U.S. appoints.
Well, Mexico has their boundary commission, and it's a bilateral commission. So, and the U.S. has their commission. The commissioners are appointed by the president and by the president of the U.S. and the president of Mexico. Or I assume the president of Mexico appoints theirs, but anyway, they have
And is the
appointed-
problem that you haven't been getting as much support from the appointees on our side as you need? Has
Well-
that been the problem historically?
I don't think we've ever gotten full support from the State Department or IBWC. Back in the 90s and even the early 2000, we made several trips to Washington even to speak to the State Department, to folks that are over IBWC about efforts but we've never had full support from, we don't feel like, maybe we're wrong, but we don't feel like we get full support from International Boundary and Water Commission to hold Mexico's feet to the fire on making deliveries on the 44 treaty.
Okay, thank you.
Thank you, Wayne, appreciate it.
Thank you, sir.
Thank you.
Chair recognizes Steve Sanchez with the North Alamo Water Supply Corporation. Steve, welcome. You'd state your,
Good morning, Chairman Larson, committee. Yes, my name is Stephen Sanchez, and I'm the general manager for North Alamo Water Supply. Better?
there you go.
Yes. Again, my name is Stephen Sanchez. I'm the general manager for North Alamo Water Supply. And I'm here basically to testify on the domestic water side. The irrigation district of the farmers are here on their irrigation water, but we on the side of the water purveyor to the public, it's a little bit different. I'm going to see if I can work this thing here. I believe I had a PowerPoint. If I can, I went ahead and
Yeah, just go
supplied y'all with a map.
Okay, that'd be great.
And basically to show North Alamo's service area and basically who North Alamo is. And basically North Alamo Water Supply Corporation is a water supplier which operates in Hidalgo, Willacy, and Cameron counties in South Texas. Our service area is 1,000 square miles, and we service a population of about 200,000. We can produce about 36 million gallons of water a day. About 10 million of that is in reverse osmosis. We have 6 surface water treatment plants and 5 reverse osmosis plants. And again, the size that North Alamo is, it includes also a lot of the cities that are there. And the problems that we have is getting the water to our purification plant. Now, the North Alamo, with the irrigation districts, North Alamo relies on the districts to deliver our raw water from the Rio Grande River. Without them, we would be unable to operate. The districts which we work with are Hidalgo County Irrigation District number 1, Hidalgo Irrigation District number 2, Santa Cruz Irrigation District number 15, Delta Lake Irrigation District, Dawn Irrigation District, and then Hidalgo and Cameron Counties Irrigation District number 9. The districts combined provide North Alamo Water Supply with approximately 20,000 acre feet of water per year. An acre foot of water is about 325,000 gallons. Now, to give a little bit, and I hope y'all have the map in front of y'all, but basically it shows the irrigation districts within our service area. The first slide that I had in there was our system and our maps, and also showing our RO plants. But given a little bit of history and experiences that we've had, in the early 2000s, the valley was going through a severe drought. Mexico was behind on releasing water. It was required by the treaty. Delta Lake Irrigation District was on the verge of running out of water for their farmers. That placed North Alamo and the city of Raymondville in danger of not being able to transport their water to their purification plants. This is also the first time that we started talking about push water. Push water is water to fill the canals in order to have our water right on top of it to get to our plants. We were fortunate that we started to receive rains at that time. Now, Raymondville, everybody's familiar with it, is up in Willacy County, probably about 40, 50 miles north of the Rio Grande River. To develop a canal going all that way, it would take a tremendous amount of water to get it up there, just to go ahead and receive drinking water for the public. And again, there's other cities that are involved within that territory. Okay, the next item here, in 2012 to 2013, the valley was suffering another bad drought. This time, the Dawn Irrigation District was the one that ran out of water. In this case, our plant number 5 and the city of Donna were in jeopardy. The water plant number 5 we have is just to the northwest of the city of Donna, and it is our largest water plant. Produces about 11 million gallons of water a day. We were able to work out a deal with the Engelman Irrigation District to ride our water on theirs. If Engelman would not have been there, it would have cost us dearly to go ahead and fill up those canals. The cost of this push water, working with Engelman, was about $30,000 to North Alamo. Not sure how much the city of Donna paid, but that was just for that little small portion. During these 2 episodes, the farming community reached out for help to the federal government, but to no avail. In the first scenario, which was in the early 2000s, they reached out to President George Bush's administration, and they received no help. The second scenario, they reached out to President Barack Obama's administration, and again, they received no help. The next basically portion that I have here is basically our solutions. Solutions basically for domestic water up over here north. After the first drought, North Alamo started building reverse osmosis water plants. This was to start mining the brackish groundwater the valley has. Salts in that brackish water is from 2,500 parts to 6,000 parts of TDS. This is a very expensive solution, but expensive water is better than no water at all. The infrastructure cost comparisons, reverse osmosis for a 1 million gallon a day RO plant, the cost to build that is $3 million. For the well to provide the water, the cost would be about $1 million. Now for surface water, for a 1 million gallon a day plant, the cost is only about $1.5 million. We also need to petition the federal government to put their money or our money where their inaction is at. If they're not going to have Mexico abide by the treaty, then they need to pay for a seawater desal plant, which is the cost for that is about $700 to $800 million. Black & Veatch was commissioned to make a study to build a seawater desal plant on South Padre Island and then pipe the water back up through the valley. Our customers and our constituents cannot afford to pay this, to build that kind of infrastructure for their inaction. So that's pretty much my testimony. If you all have any questions, I'm here to answer them.
Anybody have any questions for Steve? Steve, so you talked about the reason that North Alamo Water Supply, y'all started building desal plants because you couldn't rely on the water in the Rio Grande. Just the deliveries, the interrupted nature of it. And that's not for irrigation, but that's for the municipalities. You said that one of the plants was $3 million to build?
Yes, that's per billion gallons. You can build a plant, it's a 1 million gallon a day water plant, or you can build one that's 3 million or 5 million.
Oh, I see what you're talking about. So every million, it costs you $3 million.
Correct.
Yeah. And so the one, we visited a couple of the plants, I think in Weslaco and in the Donna area. How many plants do you have total?
We
desal
have a
plants?
total of 5 reverse osmosis plants. The one I believe, sorry, the one that you visited was in Donna. That's a 2 million gallon a day water plant. And that facility, it cost a little over $6 million to build. The well, since we had to have 2 wells there, it came out at just under $2 million for those wells, just to produce 2 million gallons of water a day.
So was the rationale to build those plants because of population growth or because of the interrupted nature of the water in the Rio Grande?
Because it's being interrupted, correct. Because when Delta Lake was on the verge of losing their water, we had no way to get our water there. So that's when we, as a responsible corporation, said we need to go ahead and find water elsewhere. So that's why we started doing the RO, because to fill up a canal, which is coming about 50 miles from the river, every water right that we'd have would probably go just to fill it up. We would not get anything at our plant. So that's when we started. And then we started putting it in strategic water plants over our entire system.
Thanks for your leadership. Thanks for coming and testifying.
Thank you for the invite.
Yeah, hold on a second. Chairman Ash?
Actually, I don't have a question for you. I guess I have a question maybe for you, Mr. Chairman, or Eddie. And, I'll be the first to admit, I'm just now dipping my toe in the issue here. But, and kind of listening to what we've heard here this morning, it appears to me that we're, acknowledging the fact that right now, I guess, Mexico is current on their delivery. But I'm getting the impression that maybe at the federal level with our commissioners that they don't really get what we're hearing here and what we're experiencing along the valley and, of course, along the Rio Grande. And so, I guess my question is, have we passed a resolution or done anything at the legislature? We have, and we've sent that up there.
When we were in real bad drought, there were a couple of us, Carlos Rubenstein, I think it's maybe 2011, we went to the State Department to try to plead our case to the highest level of person in the State Department that would listen to us. And I was younger, foolish maybe at the time, and I went in there guns a-blazing, demanding that Mexico be held accountable. And I had all my things listed out as to what can be done to hold them accountable. And they were very straight-laced, and they just looked at me in the eye and they said, Representative, with all due respect, we have a lot of issues with Mexico, and our relationship with that country is important, and your issue will be considered, and we'll let you know. Thanks for coming.
Yeah. Have a safe flight back.
Have a safe flight back.
Yeah. Well, and I certainly there's merit to this is one issue, and a lot of bilateral issues that we have with Mexico. But at a time where we're, talking about NAFTA and a lot of other issues, it just seems to me, that this is a pretty clear-cut issue for Americans and for Texans. And I just hope that we continue as a state to do whatever we can do to try to help the folks that are testifying today and explaining the problems to us. So it's been very helpful, all of you that have testified. Thank you.
Well, thank you very much, and I will, again, echo what you just said right now. I know the irrigation districts need the water for their farmers, but for the public, we need to get the government to bring some money down here to get some alternatives, some saltwater desal. We need for them to start bringing grant money down here.
Yeah, if we're going to accept the interrupted nature on the treaty and we're doing a 5-year shore, if we don't go to annual releases, then we'll be continually subjected to the irrationality of how this treaty works on the American side and that side. And Chairman Ashby, I wrote a letter to President Trump and to Secretary Pompeo.
I read those, and those are excellent letters, by the way. And I was a little disappointed, frankly, in the response that you got from the Department of State, acknowledging what we already know.
Yeah, exactly.
So,
exactly.
but thank you for your leadership in doing that.
And as I think either Wayne or Sonny said, it's a bipartisan abuse that takes place, whether it be on a Republican or a Democrat that's in the presidency. The State Department just doesn't react, and I don't know. It's wrong in every way imaginable. So, thank you, appreciate it. Let's go to interim charge 6. That evaluate the results of the expedited decertification process created under SB 573, including evaluation process for resolving disputes around the process and assessing compensation for utilities. The chair recognizes Tammy Venter with the Public Utility Commission to come up and talk about. Tammy, if you just state your name and who you represent for the record.
Hi, Tammy Venter, Public Utility Commission. Good morning, Chairman Larson, committee members. My name is Tammy Venter, and I am the Director of Water Utility Regulation of the Public Utility Commission of Texas. I am here to speak about the process for a landowner to seek the expedited release of land from a water or sewer certificate of convenience and necessity, which we also call a CCN, as created under Senate Bill 573 of the 82nd Texas Legislature, the regular session. The Texas Water Code, Section 13.254, has several provisions that allow for a landowner to seek the expedited release of his or her property from a water or sewer CCN. The two sections I will be discussing today are Water Code Sections 13.254A-1 and 13.254A-5. Section 13.254A-1 allows the owner of a tract of land with 50 acres or more that is not in a platted subdivision actually receiving water sewer service to petition to the PUC for expedited release of the land from the CCN in order to receive service from another retail public utility. A landowner may submit a petition under the Water Code, Section 13.254A-1, at least 90 days or more after the landowner has filed a written request for service with the current CCN holder. After the 90 days have passed, the landowner may submit a petition for review to the PUC to seek expedited release of the area from the current CCN. The landowner must also provide the current CCN holder a copy of the petition. The petition must demonstrate that the tract of land is at least 50 acres in size and is not in a platted subdivision currently receiving service. In addition, the petitioner must demonstrate that the current CCN holder has refused to provide service, is unable to provide the service, or is not capable of providing the service within the time frame, at the level, and at the approximate cost, or in the manner reasonably necessary or requested by the petitioner. The CCN holder may submit information to the PUC to refute the information provided by the petitioner. Within 60 days from the date the PUC declares a petition filed under Section A-1 is administratively complete, the PUC shall grant the expedited release of the area from the CCN unless the PUC makes an express finding that the petitioner failed to satisfy the elements required in the petition. The statute also allows for a streamlined expedited release of an area from a CCN in the Water Code in Section 13.254A-5. Under the A-5 streamlined expedited release method, the owner of a tract of land located in a qualifying county that is at least 25 acres or more and that is not receiving water sewer service may petition for streamlined expedited release of the area from a CCN. Unlike the expedited release process in Section A-1, the provision in Section A-5 is not applicable to all parts of Texas and applies to only 32 counties. And if you see the demonstration map that's shown on the screens, and you have a copy of it, the counties that are shaded in blue are the 32 counties where a landowner may file for the streamlined expedited release of the land from the CCN. The counties shaded in pink, which are Smith and Burnett counties, are those counties that previously qualified. However, due to population changes and college enrollment information, they no longer qualify. Medina County is shaded in blue and is also outlined in a thicker blue line. We did this to illustrate that Medina County did not qualify when the statute was enacted. However, due to population changes, it does now qualify. A petition filed under the streamlined expedited release provision in Section A-5 shall be granted by the PUC within 60 days after the date the landowner files the petition. The PUC may require compensation by the petitioner to a decertified CCN. When the PUC issues an order for the expedited release of an area under Section A-1 or under the streamlined provision in Section A-5, the PUC's order identifies what property is rendered useless or valueless, if any. If the PUC determines that no property was rendered useless or valueless due to the decertification, then a proceeding to determine the amount of compensation for the useless or valueless property is not necessary. Since the PUC adopted its own rules governing the process, the PUC has not determined that any property has been rendered useless or valueless by decertification. The PUC adopted rules regarding the determination of property rendered useless or valueless in Chapter 24.113N of the PUC's rules. The rules specify that a CCN holder has the right to intervene and a right to a determination of what is rendered useless or valueless property. If the CCN holder fails to intervene, then the PUC presumes there is no useless or valueless property as a result of the decertification. If the CCN holder and the petitioner reach an agreement regarding what property is rendered useless or valueless, they can agree on the amount of compensation for such property. If the current CCN holder and the petitioner reach such an agreement, the agreement can be presented to the PUC at an open meeting for consideration and action. This has happened in 36 of the cases out of 147 that have been filed at the PUC or its predecessor agency. Once the area is released from a CCN, either under Section A-1 or A-5, another retail public utility may not serve the area without first providing compensation for any property that is rendered useless or valueless to the decertified CCN as a result of the decertification. The determination of the monetary amount of compensation, if any, is determined at the time another retail public utility seeks to serve in the decertified area and before service is actually provided. Once a prospective utility provider files a notice of intent to serve the area with the CCN, the procedural clock starts, and most deadlines for determining the amount of compensation are tied to this date of notice. From this date, the PUC has 90 days to determine the amount of compensation for any property identified as being rendered useless or valueless. The amount of compensation is determined using an independent appraiser. Within 10 days after filing a notice of intent to serve the area, the prospective utility provider files a letter identifying an appraiser that he and the former CCN holder have agreed upon together. The appraiser is limited to only appraising the property that was rendered useless or valueless. When the parties agree to an appraiser, the prospective utility provider is responsible for paying for the appraisal, and the appraisal is due within 65 days from the date the notice of intent to serve the area is filed with the PUC. If the prospective utility provider and former CCN holder are not able to agree on an appraiser, then the prospective utility provider files a letter stating that they each engage their own appraiser at their own expense. In this scenario, the appraisals are due to the PUC within 60 days from the date the notice of intent to serve the decertified area. After receiving the appraisals, the PUC appoints a third appraiser to make a determination of the compensation within 30 days. The determination may not be less than the lower appraisal or more than the higher appraisal. Each retail public utility covers half of the cost of the third appraiser. The statute and PUC's rules specify that the valuation of real property rendered useless or valueless shall be determined according to the standards set forth in Chapter 21 of the Property Code governing actions of eminent domain. The value of personal property rendered useless or valueless is determined according to various factors outlined in this section of the Water Code. In each scenario, whether the utilities agreed on an appraiser or if a third appraiser is used, the PUC is bound by the independent appraiser's valuation of the useless or valueless property. Moreover, a CCN holder that has had land removed from the CCN area may not be required to serve the land that is removed. Thank you, and I'm available if you have any questions.
Anybody have any questions? Sort of laid it out and how the agency has looked at each of the filings, and I think you got a good handle on it. The folks, Laura's going to come up here in a minute. She's going to give sort of a contrasting view about, what the impacts were on planning and the rest of it. And then we have a lot of property owner groups and builders that want to come in and talk about some of their approaches. So, thank you very much, Tammy. The chair recognizes Laura Zent with the Texas Rural Water Association. Laura, just state your name and who you represent. Yeah, there's a mic right there. There you go. It's a lot easier.
All right. I'm Laura Zent, the Executive Director and General Counsel of the Texas Rural Water Association. Texas Rural Water Association is a trade association with a membership of approximately 750 member water and wastewater systems, the majority of which are nonprofit water supply corporations, districts, and small cities. Our members have historically provided reliable and affordable service to rural communities throughout the state. As urban areas have expanded, many of these systems have met the demands of growth, serving high-density subdivisions in urban and suburban areas. For the most part, these systems are not taxing entities, solely deriving their revenues from rates and fees. As with other types of utilities, these water suppliers have depended on the protection of a defined service area to invest in costly infrastructure with the assurance that they'll be able to pay for that investment as customers come onto the system. For cities, limits often define their service area. Municipal utility districts and other developer districts, it's their district boundaries. For rural systems, it's their state-granted Certificate of Convenience and Necessity, or CCN. The CCN provides these systems the exclusive right and obligation to serve anyone who requests service within a specified geographic area. Having a defined area to serve remains critical to justify the investment in costly infrastructure and water resources required to operate these systems. As Tammy mentioned, legislation has eroded this protection for the systems with CCNs, starting with the legislation passed in 2005 that still took into consideration a utility's ability to serve prior to decertification. That was the 13254A5 provision that she discussed. In 2011, Senate Bill 573 created a mechanism whereby a landowner can automatically decertify an area regardless of the utility's investment and ability to provide service, and that's the 13254A5. Although utility service area may now be picked apart, the obligation to provide service remains the same. The system capacity requirements dictated by the Texas Commission on Environmental Quality also remain the same. The legislature has made water infrastructure investment a priority in the state water plan through the SWIFT funding program of the Texas Water Development Board, including a goal that 10% be invested in rural infrastructure projects. The erosion of the CCN laws is counterproductive to these policies and makes investment in infrastructure for these systems more speculative. The testimony in support of Senate Bill 573 in 2011, the year it was passed, described the scenario of a small rural system with a large service area that the system was unable to serve and did not have the infrastructure or water resources to serve. In this scenario, if the law made it difficult for the landowner to receive service from another provider, the law needed to be amended. However, the way Senate Bill 573 has been implemented by the Public Utility Commission, systems are being decertified that have the ability to serve at an urban standard, have made significant investment in infrastructure, have infrastructure in close proximity to the property being decertified, and have significant water resources in place to serve the area. Senate Bill 573 has become an automatic process regardless of the utility's capacity to serve. The testimony in support of Senate Bill 573 in 2011 also explained that the bill did not change the compensation provisions of Section 13254 of the Water Code, and that water systems would be compensated for any lost investments. The data that was, I think, provided to the committee by Ms. Benter from the Public Utility Commission, or that I was sent on Monday, shows that of the 215 decertifications granted by the commission, only 3 have been awarded compensation. Since the Public Utility Commission passed its current rules regarding compensation in May of 2017, there have been no compensation awards. Utilities know that the only way to receive any compensation is through settling for any amount outside the PUC process. And from the data that Ms. Benter provided, it shows that there are a number of systems that have settled on compensation amounts, but the vast majority have not received any compensation. And there's an incentive to, when settling, just to get any amount that you can, because it's going to be better than you can get at the Public Utility Commission, which is nothing. Senate Bill 573 has been exploited by cities to take over the service area of other utilities without providing any compensation. Section 13255 of the Water Code provides a mechanism for a city, after annexing an area, to take over the service area of another utility, subject to providing compensation per the factors set forth in that law. To get around the compensation requirement, cities are telling developers that the only way they can proceed with their development is to first obtain decertification from their water provider under Senate Bill 573. We've seen several mechanisms employed by cities, including refusing to provide sewer service, not approving plats, not approving the formation of a PID, and others as a way to require decertification. In a number of these cases, the utility that was decertified was the more capable service provider and had the facilities in closer proximity. In one case, the landowner was unable to get service from the city after being required to decertify and had to request the PUC to put their property back in the service area of the original utility at great cost to all parties involved. Why does all this matter? First, it is in the public interest that these rural systems remain solvent and continue to invest in infrastructure and water resources to ensure that there is service available in these areas into the future. Second, decertification has an impact on current customers. Current customers have been partially or sometimes fully funding the necessary investments to accommodate future growth through their water rates. New customers, when they materialize, share in the utility's fixed cost, including debt, and help offset future cost increases. As a result, everyone benefits from economies of scale. However, when new customers connect to someone else's utility instead because of decertification, and the utility isn't compensated for these lost customers, water rates need to increase to existing customers. I'll conclude by saying that Texas Rural Water Association appreciates that this issue has generated enough concern to be included as an interim charge and that you're taking the time to consider it at this hearing today. I want to thank Representative Lucio, who stepped out, for leading the charge on this issue and for advocating a fair process. We also want to thank Chairman Larson for including this issue as one of the interim charges and for facilitating a discussion in June with the stakeholders. Chairman Larson requested that we develop consensus legislation language that creates a fair, timely, and objective compensation process for decertified utilities. We have hosted, Texas Rural Water Association has hosted 2 very productive meetings with a subset of the stakeholder group, including a couple that are going to be invited witnesses today. We recognize that decertification is appropriate in some cases and that compensation may not be warranted in some cases. However, systems that have the capacity to serve because they have made that investment should have the opportunity to realize that investment, or if decertified, should receive compensation for the stranded investment and continuing costs associated with it. Thank you for your time and consideration. I'm happy to answer any questions.
Yeah, thank you, Laura. Also, I want to thank Senator Nichols for being involved in this throughout the interim as well. Anybody have any questions for Laura? Thank you, ma'am. Appreciate it. Chair recognizes Terry Kelly with the Johnson County Special Utility District.
Good morning, members. Thank you, committee, for inviting me to give my opinion, testimony this morning. I'll tell a story that's more related to what boots on the ground with a special utility district that we are. My name is Terry Kelly. I'm General Manager of Johnson County Special Utility District. and I've been the manager for 26 years. And let me give you a little bit of a profile of our system, and then I'll tell you a little bit how decertification affects us or our involvement in that topic. We began in 1965 as a little rural water system, as most of them did in the state of Texas, and we've evolved today over the last 3 years into more of a regional provider in the south part of the Dallas-Fort Worth Metroplex. So a lot of change in a half a century there. And so today we serve a population somewhere between 40 to 45,000 people through 15,000 plus connections. We are kind of a regional water of sorts in that we provide wholesale water to the city of Alvarado, to the city of Keene. We service water utilities for the city of Joshua and also for Bethany Special Utility District. So we've got a lot going on, as we feel, more than usual, as you would see in a rural water utility. Growth in our area is pretty rampant in the Dallas-Fort Worth Metroplex, more so on the north side than it is on the south side. And if you've taken a look at what was provided by the PUC and their statistics, you'll find that a lot of systems in those growth areas, they've been affected by decertification in many cases. So for Johnson County SUD, we'll say SUD, and a special utility district is a water supply corporation that's converted to a governmental entity. So we did that in 2004. But we've got a track record of working with, and I call it service area transitions. Before it was decertified, where you take and you lose some of your CCN to somebody else. We've had experiences over the last 10 years where we've had 6 of those instances, 2 of them with cities, and others with developers, whereby we've been able to come to an agreement, about transitioning service to somebody else, because most of the time, all of the time for us, it's on the fringe area of our system, and they feel like there's a better way, or there's special needs that allows, or where their desires to go somewhere else. So I recognize that, and my own personal opinion about what the goodness of decertification is for those that want to make a decision on their own as a property owner. But there's some other things that affect us, impact us in a different way. And even though we're able to sit down and talk about that, I think that's what we lack today is sitting down and visiting with the developers that have a desire, or the property owners that want to do something different other than, let's go to the water provider here that of record, because it is a viable a system. Whenever we've grown to be what we are today, we've got, sure enough, a real elevated storage line size, transmission lines, 850 miles of distribution pipes, 46 miles of transmission line. And so, we've got the ability to do that. And so we've only had one experience in decertification. One just walked in the door this week, so we're dealing with a new one. But one about 3 years ago came in to us, and is a 1,000-acre property, 1,000 acres, and they wanted to be decertified. Previously, 2 years before that, we had done a hydraulic analysis on it, and we could serve it. We had an elevated tank, a 1 million-gallon elevated tank not far away. Sure enough, with it being 2,000 to 3,000 lots, subdivision, that was sure enough significant. But there was a phased approach in being able to have a solution for them. But yet, here comes the expedited decertification. So we've gone through that gamut, through that process. But today, 3 years later, that case, the problem that we have is that the PUC, they view providing service as something that contrasts with what the statutes say. And that is, if you don't have flowing water on the property, then you're not providing service. And so I think there are issues that really we need improvement in the statute there to be more definitive and not take a different approach than maybe what the broad terms speaks about in the statutes. In this case with this property that I'm telling you about, we went through the Travis District Court of Appeals, and they upheld for the PUC on this issue about the definition of service. And we felt strongly about this issue of service and where will it stop, or will it ever stop? But we went through the Third Court of Appeals, and they also upheld for the PUC in that. And today, we still think that there is something to be said about, let's line up our interpretation of providing service with what the statutes say. And today it awaits a reply from the Texas Supreme Court to consider this matter of providing service. Let me read from what our position paper states. As expedited decertification applications are being processed, in various cases the PUC appears to have created an unwritten rule concerning property not receiving water service, as it sidesteps the existing definition for water service in accordance with the Water Code. The PUC has been granting decertification to any property that is not receiving flowing water service, but the definition of service in Chapter 13 is very broad. It includes almost anything a utility has done towards providing service to the property in that area. Service includes any act performed, anything furnished or supplied, any facilities or lines committed or used by the retail public utility. Facilities include all the plant and equipment of all the retail public utility, including all tangible and intangible real and personal property without a limitation, without any and all means and instrumentations in any manner owned, operated, leased, licensed, used, controlled, furnished, or supplied, or by the connection with the business of any retail utility. So that's an issue today about where we could make improvements to decertification. There's something else that Laura had touched on, and that is about cities assert water utilities to be, that they will be city provided. A newer trend exists today that some municipalities direct property owners to the developer who contemplate new platting within the ETJ, which overlaps the CCN holder service area. The decree coming from the city is that the water utilities will be city provided. That's water and sewer. The unfair leveraging within the ETJ forces the developer to make an application for decertification even when the developer expresses that they would rather work with the existing water provider whose system is nearer and is readily capable to accommodate. There's a practical solution when the development includes sewer service. When the utility can readily supply water service, they can also provide the billing service for the city's wastewater collection and remit monthly payment to the city. And JSUD operates under that scenario with 3 cities and 1 private utility with no problem. So we do that. And I think the city and the water provider can work together, with one being a bona fide, viable service provider that's been there before and provided this service in this area whenever no one else would. So that ability exists. But the city which stipulates this undercuts the rationale and purpose of Chapter 13 with respect to the neighboring rural water utility. If cities can refuse to allow development under the developer, unless the developer agrees to the city being the water service provider, then cities are systematically impacting rural customer rates as the decertified utility's viability slowly erodes. Stranded cost compensation, that's something that it's a complex issue, and each case is based on its own merits, and it looks, it demands its own forensic look, with each one, because they'll all be a little bit different. Regarding compensation for stranded costs to the decertified retail public utility, the PUC has a narrow view to a fault in only recognizing property that is rendered useless or valueless. I can't think of any scenario in our system, or maybe others, whereby look, we'll only recognize this property that's been rendered useless as if it was just a pump station and it was there and dedicated to serve this specific subject area here of dispute, and so it'll no longer be used. Well, I don't see that. We spend so much time in our business working hard to do what the state would have us to do, in making certain that we've got adequate water supply capacity, ample elevated storage and line size that not only takes care of what we're serving today for the existing customers, but taking care of what the future connections with serving them with more water, or the elevated tank. It's not sized just to take care of those that are here today. So, there's pieces or other elements associated with stranded cost besides just some piece of property we'll recognize only if something in itself has been rendered useless. So that there's more to be said, that ratepayers of the decertified water utility are due more consideration than just property that is rendered useless or valueless. Thank you for the opportunity to speak, and I'll answer any questions.
Anybody have any questions? What happens in Hill, Hood, Palo Pinto counties around you? Those counties are not in the designated counties.
Yeah, those that are a little bit further out. And of course, they're not in the area. They're designated to be expedited, or decertification takes place with those counties.
I just want to know what's going on the ground. As the developments happen out there, they are not targeted under these 40 counties that were designated. So, do the developers go in and negotiate a little bit differently than taking the CCN?
I don't know a whole lot about what goes on outside of our area, but I think one of the most important things that they do is there is more motive to let's communicate, let's talk together. Here's the developer issue, and what can you do as the water utility provider? What are you able to do? So I think that's what's lacking in this whole process today, is that now all of a sudden developer, property owner can just lawyer up, and you'll get your copy of this filing and off we go, and there's no discussion prior to. And I think in this whole process, and we've seen and heard some of the outcomes after the fact, that they come back and find out that the other water provider couldn't provide adequately. And now let's redo it. Oh, redos are really fun. I'm not getting emotional about that part, because it's just, it's like we need to do something to fix those things ahead of time. And I think if we could just apply ourselves, and there's no substitute for good communication, to talk about it up front, because we've got that track record. That's my message to you today, is that us being probably the largest special utility district in the state here, and of course there's lots of others smaller, but then a few of them that are our size, but looking at this in a practical way and knowing that, if somebody's got another way to serve it, I recognize that, but whenever it really comes to our ability to serve, and if we can, you can probably work through it a whole lot faster than the whole process itself if we could just talk about it first.
Thank you for your passion, Terry. Appreciate that. Anybody have any questions? Yes. Representative Burns.
Terry, I want to thank you for making the trek down here to Brownsville to provide testimony for us. And I want to thank you. I think you do have a good track record of working in our area with developers and with other folks as you see the needs develop, and as our county grows. We do live in one of those areas that's one of the quickest, fastest growing areas of the state. And I think y'all do have a really good track record working with cities and other entities to make sure that folks are provided for. And I appreciate that. I appreciate your perspective too. And it's a complicated issue, as you said, and appreciate your counsel as we go forward.
Thank you, Representative Burns.
Thank you.
Thank you, Terry. Appreciate it. Chair recognizes Scott Norman with the Texas Association of Builders.
morning, Mr. Chairman,
Good morning.
members of the committee. Good to see all of you again. My name is Scott Norman. I'm the Executive Director of the Texas Association of Builders. We're the statewide home builder, remodeler, developer, and associate members. We have about 11,000 members across the state. Our members, companies, and their subs and other affiliates employ about 511,000 Texans and constitute about $36.5 billion annually to the Texas economy, the residential construction, both single and multifamily sectors. We have been involved in water generally and this issue specifically for a number of years. As you know, working with this committee and others on the SWIFT funding and other water issues. Water is one of the limiting factors, if not the most, for our industry moving forward. The availability of water, water for subdivisions, for houses, for residences, for apartments, and whatnot. As our state continues to grow, we're leading the nation in housing starts, going on 10th year in a row. I would argue the need for a process to protect property owners to make wise decisions on how and where and when they're going to develop their property, and from a big part of that is where they're going to get their water and sewer services, is more important that this legislation or a version of it consists today than it did in 2011. In 2011, we were coming off the biggest downturn in our economy nationally, the downturn in 07, 08, and housing starts are up significantly across the state of Texas, not just in the 32 counties that this statute applies to, but all over the state. And there is a need for property owners. Frankly, our members, when they are developing property or someone that owns a farm or what have you, are having to deal with a state-granted monopoly. Our members work in the private sector completely. They're having to raise capital, and they need water. And they really don't care where the water and sewer service comes from, as long as it is a reasonable and fair price. And so this process and this legislation came about after several sessions of working towards a process to make sure that property owners were able to have some input into that process. We appreciate the opportunity to work with this committee, other stakeholders going forward to look if changes need to be made. We certainly will consider those going forward, but I do want to stress the importance of a decertification process as we meet the growing needs of this state. You know, over 1,000 people to 1,500 a day moving here, internal growth within the state. We've got 4 of the top 10 housing markets in the United States and have for over a decade. We need water to make that happen and make this economic engine of Texas keep going forward. So be happy to answer any questions and look forward to working with all of you going forward on this very important issue.
Anybody have any questions for Scott? Scott, you heard the testimony of Terry talking about that they're doing build-outs, they're doing projections of where the growth's going to happen in Johnson County, and then you have a landowner of 1,000 acres that decides to go through the expedited decertification. You know, I guess somewhere the issue that Senator Nichols talked about, that if that happens, the issue of compensation, the PUC, we're struggling with that if people, you know, these stubbed out main lines going into that development, for whatever reason, landowner, farmer, developer, whatever, decides to go with this process, you know, the compensation for doing that stub out and the projected. And I think you had representatives in our stakeholder meetings talking about how we get there. So how do you see this moving forward as far as working that issue out?
Well, 2 things. I think, you know, throughout the districts or the companies that make these improvements are due compensation to the portion that's attributable to the land that's being removed. I would argue it was tilted a little too far the other way prior to this legislation being enacted. I think, you know, the PUC tries to do the best job they can in the framework that they have to make those calculations. And I know we received Shannon forwarded data that we got from the PUC, I guess, earlier this week. And you know, we haven't broken it down yet, but we will be looking at that to analyze it and see. I think those are all individually and case specific. But, you know, we want to make sure it's fair. We certainly want to make sure it's fair to the holder of the CCN, that they are not getting left holding the bag, so to speak. That being said, we can't go back to the days of some of the horror stories where there were very exorbitant demands made very high price demands made to be released from a CCN because, as you know, time is money, and sitting on the ground trying to make these very expensive projects happen when there is great demand to get these houses or multifamily projects on the ground, sitting around with a CCN holder that is either unwilling or unable to provide water is a death knell to that project. And again, the state, while the CCN process and the exclusive territories for service, I completely understand it. It makes sense. It certainly made sense in a rural state, in rural areas of the state, but in these growing areas around, and I will say it's not just those 32 counties. I would argue if we're going to discuss this, I think the property owners all over the state deserve protections, and we shouldn't have two standards. And there's bigger issues with the changes y'all made last special session to the annexation statute. You know, ETJ are in play. Most of the urban counties now, or it's much more, it will probably be more difficult to do annexations going forward. There's a lot of bigger issues involved in the areas surrounding our growing communities around the state, but this water CCN issue is a big part of that. And so we want to work and make sure that there is a balance there, but that we can continue to grow and meet the housing needs of our state.
Yes, Chairman Ashby.
Scott, you mentioned cities and ETJs, and I was struck by Mr. Terry's presentation here that we've got apparently cities that are now in working with your members and developers in the ETJ area specifically that are, I guess, I think he used the word decreeing or requiring that those developers utilize city water services. Are you hearing that from your membership as well?
You know, I've heard allusions to that. I will tell you, since the passage of this legislation in 2011, we have not heard as many outcries about abuses or about problems in the CCN water delivery as we did before the enactment of this statute. You know, our builders and developers, they have to get approval from all levels of government going forward, and certainly cities, both in the city and outside in the ETJ, have extensive powers when it comes to platting. They don't zone outside in the ETJs, but they do control the platting process. And when you're getting, I think he alluded to, you know, you may be getting sewer service from one and water service from others, and I've heard that it can work very well, and there's ways to make it work. You know, Representative Ashby, every development is unique, and I can't speak to the specifics on any of those, but I will say, and I know that there is a practitioner, Mr. Trey Larry, is on the agenda here in a second, and I know he has more experience directly dealing with these projects than I ever would, but he may be able to speak to that. But you know, there is a balance there, and there is an issue, and you know, as you know, based on our track record versus some of the cities and legislation over the years, sometimes we don't get along that well. But in 2011, we were united in support of this legislation.
Right. I just, you know, I'm not putting words in your membership mouth here, but it just seems to me that from a development perspective in an ETJ area, that it should be up to the developer and the property owner to make that decision and not be forced to go use city water services. That should be something that is discussed and negotiated and not
Our association and our members will always default to the property owner ultimately who owns that land, and who has made that investment to try to do something with it or improvement. That would always be our position. And again, it is about you know, providing the most economical and expedited water supplies that we can get to these properties. Yes, sir.
Scott, thanks for coming down, testifying.
Thank you for having me.
Chair recognizes Trey Larry. Morning.
Good morning, Good morning, Mr. Chairman, members. Trey Larry with Allen Boone Humphreys Robinson in Houston and in Austin. I and my firm represent landowners and developers and home builders in developing infrastructure and public utilities for new development projects. And I've been involved with and working on CCN reform since at least 2014 and worked in support of the major reform legislation passed in 2005 and 2011. I've submitted written testimony that gives an overview of that reform timeline and legislation, as well as a summary of the significant issues that led to that reform. And rather than repeating that written testimony, I'd instead like to talk about how my clients approach water utilities, and in doing so, Mr. Chairman, get to the core of what I think my brief to you was, which was to look at compensation and whether that is working or not. I'm not intending to relitigate the need for decertification. Landowners and developers need water, and water is scarce. If a water utility has water and the cost of treatment and distribution of that water are fair and reasonable, landowners and developers will want to do business with that utility. Decertification is not the first choice. My economics degree may be from Texas A&M, but I still know that monopolies and lack of competition distorts prices. And the key to House Bill 2876 in 2005 and Senate Bill 573 in 2011 was to allow landowners to make choices as to water and sewer providers, thus creating competition and lessening the impact of monopoly pricing. If a landowner is considering developing a tract of land, one of the first things they will do is have an engineer evaluate water and sewer. If the land is within a CCN, this process will start with that utility. Does the CCN have water? How much? How far away? What are the capital costs to bring that water to the tract? What other capital costs or impact fees or water reservation fees are to be charged? In most instances, a landowner developer will work with that CCN utility and not seek a decertification. There's been a discussion about a landowner who sought decertification and then wanted to come back, and I'm aware of one instance that keeps talking about over and over again, bad facts make bad law, and I think that is not a trend or a pattern, but it is one particular instance. In my experience, landowners seek decertification in two instances. One, when the CCN utility can't provide service. It doesn't have water or it's too far away. And number two, when the cost of service is too high and there is a more cost-effective water provider. Some may testify to you that landowners aren't capable of making these decisions, or that a state agency must review and evaluate landowner decisions. They may also testify that relative cost between supplies are unimportant, and they are wrong. The costs are very important, and this factors into compensation. Let me explain how I have seen service typically provided for and paid for in a CCN situation. Most CCNs consider service to a developer as, quote, non-standard service. And this means that the CCN utility requires a developer to pay for 100% of the facilities to serve the land and to pay those costs up front. Essentially, the utility says, we will serve you and sell you water at our standard rates if you first pay to design and construct all of the facilities. And this gets talked about as a right to serve or an obligation to serve by the CCN. But it's only a duty to serve if the landowner will pay for all the costs up front. And this is key when you're talking about compensation after decertification. How much compensation is owed or can be owed if the landowner is going to be required to pay for everything in the future? Homeowners eventually pay these costs through higher home prices or taxes or rates. My firm has worked on a few projects, about a half dozen, where the landowner chose to decertify. Again, most landowners do not choose to decertify. In all of the decertifications my firm worked on, all parties agreed that there was no service, that there were no facilities, and that no compensation was owed. The CCN utility agreed. I don't know, but I suspect that this is the case in most decertifications. Obviously, to get to the point of an agreed-to decertification, there was a conversation and there was communication between the landowner and the CCN utility. There was an investigation and an evaluation by engineers, a decision by the landowner, and an agreement by the CCN utility, all before filing a decertification petition. So I don't think this was a surprise. This was part of an evaluation of the water. I support the right of landowners to decertify, and I also support the payment of fair compensation to the CCN utility if and when there are facilities that are stranded by the decertification. As I've mentioned, I believe that compensation is not a factor in most decertifications. The compensation process needs to be fair, but it also needs to be quick and efficient. A central tenet of House Bill 2876 and Senate Bill 573 is expediting an otherwise lengthy and costly process. So any changes to the compensation process need to be carefully evaluated for the time, cost, and efficiency in addition to fairness. Chairman Larson asked me to work with Texas Rural Water Association and other stakeholders to study the current system of compensation, to identify problems and propose solutions and report back. As Laura mentioned, a group of stakeholders has been meeting and working diligently. It is important to me, because I know it's important to this committee, that our work be data-driven. How many decertifications? Where and when and in what circumstances? Were there stranded facilities? What types of facilities? Was there a dispute over compensation? Why? How was it resolved? And this is complicated even in the process and the data that you've heard today. As Tammy mentioned, it's a two-step process. So decertification is determined, and then later, maybe years later, compensation is determined. So the fact that there have been decertifications, but compensation hasn't been awarded, may mean that that compensation decision is not ripe, and it hasn't been time to address compensation. Only the decertification piece has been addressed. These are the things that we need to ferret out of the data. Just within the last week, we received a first round of data from the PUC, and I'm still sifting through that data, and I'll have questions and I'll follow up, try to work on that data. Nevertheless, stakeholders have been working in good faith and have been open and had productive dialogue. Mr. Chairman, I pledge to continue working in good faith with that stakeholder group.
Thank you, Trey. Anybody have any questions for Trey? Appreciate your diligence working through it and the stakeholder groups, sitting down with Laura and trying to figure out where the middle ground is as far as the compensation is concerned. Thank you, sir. Appreciate it.
Mr. Chairman, next time Mr. Larry comes to testify before our committee, maybe we need to put an arrow on the end of the microphone that he's supposed to speak in.
I figured that was coming. Chair recognizes Joe Freeland. Joe, if you'd come up and just state your name and who you represent.
Good morning, Chairman, members. Joe Freeland of the law firm of Matthews and Freeland. We represent a bunch of cities around the state. And I'm going to testify to you all today on behalf of the city of Tyler, who, if you look through the PUC's data, you'll see that Tyler was one of the advocates of both HB 2876 and SB 573. And I'll get to why, perhaps, if I have time this morning, as to why Tyler was that interested in it. From my experience with regard to the cities, the city's primary interest in these decertification proceedings really has been facilitating development. Developers are a very important interest group within most municipalities. They have an ear, they have the council's ear in almost every city I've worked for. And if the developer wants something done and it makes sense for the city's going to do that. So the most part, when cities have participated, at least my clients have participated in a decertification, or the notice of intent to serve after decertification. It has been developer-driven. But one thing to note about 573 is it works against cities just as it would work against a water supply corporation or any other investor-owned utility. Their CCN, except for the very large cities, their CCNs could be taken decertified just like any other utility. And if you look on the PUC's list, you'll see there's a long list of cities in there whose CCN has been taken through the decertification process. In my experience with my clients, they have given up CCN to other utilities when it made sense for the development. If it was better that somebody else served that development, the cities have given up the CCN. So I think Tyler gives a good example sort of on both sides. So Tyler, within the city of Tyler and its ETJ, there is one water investor-owned utility and one sewer investor-owned utility. So with regard to water, Tyler and that investor-owned utility share within the ETJ, they have a dual CCN. So both entities have the right to serve or the obligation to serve. Outside of the city limits, the IOU provides that service. As Tyler annexes into that area, when it makes sense for the city to come in, when the density gets great enough for the city to come in, city goes in, has a long-standing relationship with that IOU. They compensate the IOU for its facilities that are there, and then the city becomes the provider. Now, with regard to the sewer IOU, which is in the southern part of the city, that IOU provides poor service. It has a horrible environmental record. It has high rates, both to what it charges its ratepayers and the amounts of money that it extorts from the developers who want to develop in that area. And it was that sewer IOU, which has always led Tyler's pushing for reform in the CCN area, because development in that part of the city came to a grinding halt. And after 573, only after 573 was the city able to get development started back again in that area, and only in those areas that were decertified from that IOU. And it was important to the city of Tyler because it had invested a lot of money in non-water and sewer infrastructure. It had invested in parks and streets and libraries and other drainage and other city services, which really weren't being used because no one was developing there. So with regard to that IOU, there have been 10 maybe decertifications in that area. Tyler has gone through compensation proceedings both at TCQ and the PUC with regard to those areas. And in every case, compensation was determined to be zero. Zero. And so from the city of Tyler's perspective, 573 is working great. Even the compensation part of it seems to be working well. I have heard, we have been working with Rural Water on developing some fix to this at Representative Larson's request. And I've heard those situations where there are utilities who aren't able to recover through the compensation process now money that they might or arguably should be able to recover. And so we're working with that work group at Rural Water. And one thing I would just sort of like to leave with y'all is if we're going to reform that compensation provision, there's 4 or 5 things y'all need to think about in doing so. The first is I think we need a clear standard as to what that compensation is supposed to do. Is it supposed to protect those existing customers who will be left in that utility? We want to make sure that their costs don't go up. If that's what we're trying to protect, we need to make that clear in the statute. And the second could be not to disincentivize proper planning. We don't want those rural systems to not plan properly going forward. We want them to still have the incentives to do that, and we still want them to spend the money to do that. The second thing is what I've sort of noted as sort of advance notice of planning. So I work for municipalities. They charge impact fees. To charge an impact fee, We have to do an impact fee study. We have to lay out where we think the lines are going to go over the next 10 years, where we're going to build storage tanks, where we're going to build wells. We work out the price of all of that, and then we tell the developers, okay, if you're going to develop anywhere in the city or in this part of the city, you're going to pay us so many $1,000s per connection, because we've worked it out ahead of time. It's a transparent process. The developers get to participate in that process. Everybody gets to see what those charges are. Now, in these rural systems, we don't have that. The developers show up. They don't know what the utility has been doing with regard to planning. So they have no idea what that charge that they're going to see is going to be. So maybe in the compensation, if we start talking about compensation, maybe we start talking about, do we make these utilities go through a little bit of formal planning, formal and transparent planning up front, so we all know what those costs could be down the road. To reiterate Trey's remark about expeditious proceeding, yeah, I think it still needs to be expedited. I think we might get there if we try to balance the incentives properly. You know, as Trey stated, in the past, the incentives were always with the utility. Maybe we've gone too far the other way to give the incentives to the landowners, to the developers. But we've been talking in the group about some incentives that could be used to sort of balance that out. One, to get the utility to come forward with a good faith proposition up front, and then a way to sort of expedite a decision going forward. And then if we have to go litigate something, which, you know, God forbid we'd have to do that, we do that down the road and don't stand in the way of the development. And finally, the last thing I think we need to think about in compensation is making sure that whatever money is paid in compensation actually goes to the purpose that we thought compensation was for. So if compensation is for protecting the existing customers, we need to make sure that it is accounted for within the utility in such a way that it actually goes to that purpose. You know, we're not just talking about investor-owned water supply corporations or special utility districts. We're also talking about investor-owned utilities. And so I would be concerned if we were paying compensation which was intended to protect their future customers or their existing customers in the future. We want to make sure that that money didn't end up in the pockets of their shareholders and did not go to the purpose that we wanted it to go to. And that was all I had. I opened any questions y'all might have for me.
Anybody have any questions? Very thoughtful. Appreciate your presentation. Members, this concludes testimony on our second item on the agenda. We'll move to the next agenda is interim charge 3B and 3D, evaluate the status of groundwater policy in Texas, including the following issues: developments in case law regarding groundwater ownership and regulation, and the appropriate consideration of the service area of a water supplier when groundwater resources are allocated based on surface ownership. Begin. Chair recognizes Representative Burns to talk about HB 3028, legislation he filed last session.
You bet. Thank you, Chairman Larson, and committee members for undertaking this role. I know you all take it very seriously, our interim charge here to visit this topic, and I've taken it very seriously my last two sessions as we've filed legislation to impact or even define those two magic words, fair share. And you know, and so just a little background for the history of House Bill 3028. It was born out of a desire to protect private property rights, and that is really the nexus. That's really what started it all, and where I'm coming from on that bill. And our efforts there were to define fair share in a way that ultimately takes it in the direction that I believe the Texas Supreme Court has been taking it and for decades, for literally almost or more than 100 years, and that is in a way that will define groundwater ownership in place under a person's property and protect that right. And our definition that we used in the bill, for those of you that don't remember, I'll read that for you here. Fair share means a reasonable quantification based on the best available science of the amount of groundwater in place beneath each tract of land overlaying an aquifer, a subdivision of an aquifer, or a geologic formation that may be produced. A, under the applicable desired future conditions, so we tried to take that into account. B, under the operating and hydrological conditions of the area, which must be taken into account. And then C, without resulting in the confiscation by uncompensated drainage of the fair share of groundwater in place under other tracts of land. So we toss around the term correlative right, but in my mind, correlative right and fair share aren't exactly the same thing all the time. They can be. I think that the Day case has several implications. I think one of the things it does is again prove that ownership of groundwater in place underground under a landowner's property. But it also allows for other considerations. But first and foremost, we can't separate the fact that the water in place is owned by the landowner. And I think that we always have to drive back to that. So if you look at our bill, there were several places where we amended Chapter 36, and most of those little references were to point us back to the fact that the original purpose of groundwater conservation districts, in my opinion, as they were created back up in the High Plains, were to protect your property, protect you from your neighbors draining your water out from under your property. That was kind of the beginning of that, and so we reference that throughout the bill, and try to get to that conclusion. But it's a complicated issue. We need to discuss it. We need to hear all inputs. I know that there are some folks that interpret the Day case much differently than I do, and I'm anxious to hear their arguments as well. But that is where we begin this discussion, Mr. Chairman.
Thank you, Representative Burns. We'll impanel our first panel. Chair recognizes Sarah Schlesinger, Doug Shaw, Alan Day, and Neil Hodgins. Sarah, why don't you kick it off, if you don't mind? Just state your name and what organization you represent, if you could, all of you. Is that working? Are those on? Maybe you've got to turn them on the back there.
Is it working now?
Yeah, there you go.
Perfect.
Sure.
All right, Chairman Larson, members of the committee, thank you so much for having me to testify again. My name is Sarah Schlesinger. I'm the Executive Director of the Texas Alliance of Groundwater Districts. TAG is a 501c3 that represents 85 of the 98 groundwater conservation districts. It was created in 1988 to serve as an educational resource to the districts, as well as a resource to the legislature, to agencies, and the public on groundwater policy. And we're delighted to be here again to testify. In light of your groundwater discussion on this interim charge, both on the consideration of a water supplier's service area and the concept of fair share, it's my hope to provide to you testimony on how it is that groundwater districts permit and why, and really to focus on that, especially because you'll be hearing from individual groundwater districts after me about how it is that they treat those individual issues. So I'd like to start with the foundation, which is just a reminder that Chapter 36.116 of the Water Code states that GCDs may regulate the spacing of groundwater wells and production of groundwater by the development of rules. And the objective of those rules is to minimize, as far as practicable, the drawdown of water, the water table, or the reduction of artesian pressure to control subsidence, to prevent interference between wells, as you referred to, Representative Burns, between neighbors, and to prevent degradation of water quality or to prevent waste, right? So that's the kind of the foundation of the mandate. And the way that statute defines that is that it identifies 5 ways in which groundwater districts may develop rules to manage that. And so the statute provides that a district may do the following 5 things. 1, preserve historic and existing use. 2, regulate based on tract size or acreage. 3, consider the service needs or service area of a retail public utility. 4, limit water produced based on contiguous surface acreage. And 5, managed by groundwater management areas. So the statute then goes on to say that permitting methods should be based on what's appropriate for the hydrogeological condition and needs in the district. And what I really want to emphasize here and kind of leave with y'all as a primary message is that in reviewing the member responses to our GCD index, which is a database that we maintain in surveying our districts on an annual basis, what we found is that delineating which permitting approach a district is using is really not a black and white matter. A number of them, what we found in our analysis is that districts most frequently use or have used a combination of those 5 MEs in their permitting approaches and their rules, and that it's really used to address the nuance that exists in Texas, both hydrogeologically and in terms of use, right? So that's kind of the main thing that I want to leave with you is just in thinking about those categories, we found that it's not as simple of a black and white kind of categorization. So then speaking specifically to the permitting of a public water supply, we went through and asked this year for our districts to identify how it is that they treat specifically public water supplies and the type of permitting, right? So they may be using a series of different permitting approaches generally in terms of an operating, but specifically to a public water supply. And these are the numbers generally kind of groups that we found. And I have to place a caveat to say that only 72 of our members have provided responses so far, so there's still a couple that we're seeking. So these are still draft responses. 27 GCDs permit based on demand or historic need based. 17 permit public water supplies based on surface acreage ownership. 4 of them permit based on the CCN, and then 17 of them permit based on some combination or other, and then we've got 7 districts that are still in the process of developing rules, right? So I just wanted to share that with you. In regards to legislative action and positions, respectfully, TAG took a position in opposition to Representative Lucio's House Bill 1318 and to Representative Burns' House Bill 3028 last session. And in both cases, TAG's position was premised on the belief that differing needs, uses, and hydrological conditions require different permitting approaches. And as an alliance of districts that uses different frameworks, we believe that the current statute allows for the flexibility to address that nuance, and we recommend that it not be changed in either of those cases. So finally, during the interim, our legislative subcommittees have been very busy. We have the chair of one of our legislative committees here, Alan, and they've developed 2 papers that we've submitted to you today with my written testimony, one on permitting at large and the other one specifically on water supplier service area. Both of those papers have been approved by a majority vote, both within our legislative committee and our executive committee, and we've provided them to you today if you're interested in some of the more nuanced discussion about why we believe that. So that concludes my testimony. Happy to take any questions.
Anybody have any questions, Sarah?
I do.
Yeah, Representative Burns.
Just one really quick one.
Yes,
First of all, thank you so much. Appreciate your testimony, and
Yes, sir.
I understand your opposition. Don't know if I agree, but I certainly understand. I appreciate it very much. But so, because one of the hangups that I have is that, and I've seen it as we've gone across the state, and we've discussed even in certain areas of the state the creation of groundwater conservation districts, is that you can have a groundwater conservation district created in an area to serve the same folks, yet depending upon the board makeup and the philosophy behind who created the district or why it was created, it can have almost an opposite effect. It can be put in place to protect a group of landowners or whatever, or protect their resource, or it could be put in place to kind of bring along that water and move it to an area without just compensation, in my opinion. So I think I see a problem there. So the purpose of the bill, and my hope, is that we will kind of redirect in all that we do, looking at, okay, we first acknowledge the property right. We first must honor and acknowledge that groundwater is owned by someone first, and then we can. But we have all of these other tools that help us regulate it, like the DFC and the hydrologic conditions of the aquifer, and in certain cases even maybe historical use. Different things are brought into play there, but but that's my issue, is we can have a GCD set up in an area to regulate that water, and it can be for completely different purposes based on the makeup of the board of that. And I think that politicizes it, you know, and I just would like to see us fundamentally protect what I think the Constitution protects, and that's their property right.
Sure.
So I don't know if that's a real good question, but it's more of a statement, I guess.
Well, I'm happy to speak to it. I think that you bring up an excellent point, and what I view as a benefit of the way that Texas has chosen to manage its groundwater through decentralized local management is the fact that you have the capacity for local boards to make different policy decisions. And you're right, sometimes they are differing policy decisions. But for the most part, those boards are created to be representative of the constituent base there, right? And those are the people who ultimately own the property right to the water. So I think that I hear you on it, but I think that there's benefit still in being able to make a local policy decision about how you choose to allocate the resource.
Well, and don't mistake what I'm saying either. I also believe there's a fundamental role for GCDs, and I believe that those closest to the people govern best, no question about it. So I'm not opposed to groundwater conservation districts and the role they play. I'm just opposed to the ones that don't honor property rights. So I'll just stop there.
I'll add as another thing, just thinking about those 5 different ways in which a district may regulate it. You kind of get stuck in a hard position because on one hand, recognizing the private property right in terms of the surface acreage and in the way that fair share was put out there, there's also investment-backed expectations, and there are also property rights that are really deeply embedded. So a lot of our districts that have strong historic and existing use permits as well, there's a really, really strong private property within that as well. So it becomes kind of a balancing act between.
Right. Well, you're exactly right. But again, we only have investment-based expectations on property that we own. But excellent point. Thank you.
Anybody else have any questions? Doug?
Yeah, Mr. Chairman, Doug Shaw, General Manager with Upper Trinity Groundwater Conservation District. I have a PowerPoint. I have a PowerPoint presentation. I don't know what the easiest way for me to utilize that would be. Would you like me to go back there? Yeah, thank you. And I've also got handouts, copies of my presentation.
That's great. Yeah.
If the committee would like those. And Representative Burns, while they're getting that started, I'm gonna give a little context, a little background, a little bit of technical, and then I'm gonna get into a little bit of specifics of our district. But you can take it as you want. I grew up in Godley, so I probably don't know nearly as much as I think I do.
Yeah, pretty close.
It's in his district, so it's Johnson County. So
Wildcats are good people too.
Yeah, I think so. So again, Doug Shaw, General Manager, Upper Trinity Groundwater Conservation District. Our district covers Hood, Parker, Wise, and Montague counties, just to the west of the Dallas-Fort Worth Metroplex. We were actually created in response to the TCEQ designation of the North Central Texas Priority Groundwater Management Area. That designation was made largely in part, I'm sure many of y'all have seen this map before, the largest recorded drawdowns in the state of Texas are in the Trinity group of aquifers. Really, those dark red spots are Tarrant, Dallas County, that's Arlington's right in the center of that northern one, and that's McLennan County, Waco area down in the southern darkest spot. To quote Dr. Robert Mace, I'm sure all of you are familiar with him, is one takeaway from this map is all aquifers don't pump the same. So, I'm sure everybody's familiar with the Ogallala. Sometimes 20, 22 times as much water is pumped out of the Ogallala as pumped out of the Trinity, but because aquifers act very differently, you see much greater drawdown in the Trinity. So what this shows here, one reason I'd like to speak to is the alignment, the creation of our 4 counties makes geologic sense because we sit on the northern outcrop of the Trinity Aquifer. And for those of you that aren't familiar with what the outcrop is, it's a portion of the aquifer that has no confining unit or no impermeable layer that separates the aquifer from the surface. It's the shallowest, it's the thinnest, it's the least productive portion of the aquifer. These cross sections, what they show is, these are the cross sections across, and they're really hard to see, and I apologize for that. From left to right, our northernmost county, Montague, and Parker, and then Hood are on the far left. And what this shows is this is how the Trinity Aquifer dips. Out where we are on the outcrop, it's very thin, it's very shallow, and not very productive at all. You know, and this kind of speaks to what I like to tell people that in our district is yes, there is a tremendous amount of water under our ground. In the Trinity, most of it is to the east and south of our district. If you were to even pump a small percent of, and I'm not going to try to make up that percent, if you were to pump a small percent of what's actually down in that entire aquifer, you would completely desaturate our entire district because we're sitting there on the upper end. It's, you know, gravity works, right? Water flows downhill. And so all the water is down dip or to our east and south. You know, and Representative Burns, Johnson County is just slightly to the east of our district, but mostly confined, mostly in the down dip. And just a real quick, I like to use this this little graphic quite a bit because it really talks to how, very simply put, how an aquifer like the Trinity, which is a dipping aquifer, how it works. There in the outcrop, you know, you can see that simulated well. The water level you see in the borehole in the outcrop is equal to the saturated water levels in the sand. As you move down dip, the water level in the borehole, the water level in the well is far above the top of the aquifer. In other words, you're measuring hydraulic pressure versus where we are in the outcrop, you're actually measuring the water table. And this also speaks to, you know, I've heard multiple people say, you know, there's so many different DFCs in GMA8. Well, they're not really different DFCs. You know, a drawdown of, you know, 100 feet in Denton County to our east causes maybe a 10-foot drawdown in Wise County. They're not really different. They're just, in the east, you're drawing down hydraulic pressure. In the west, you're drawing down you're actually desaturating the aquifer. You're actually drawing water out of the sands. Hopefully that makes sense. Real quick, this is just, if none of y'all have visited this is a really cool tool the Water Development Board's got, and I know Larry French is going to speak later. It's a 3D major aquifer, or it's a major aquifer 3D viewer. You can actually move them around and look how it's a physical, you know, it's basically just a physical model of what these aquifers look like under the ground. It's really cool to play around with. If you're anything like me, when I first found this, I spent, you know, way too long geeking out on it, so yeah, that's me though. So now let's talk a little bit about our district. I think that, you know, as I listen to the previous testimony today, as I listen to most testimony that comes before this committee, we talk about permitting, we talk about, you know, large water users, public water suppliers in the Panhandle High Plains. You see agriculture being the large water user. Our district is very unique. What this shows is the blue bars represent public water supply use. The orange bars are water used for oil and gas purposes. So in the Barnett Shale boom, you saw a lot of water being used for you know, hydraulic fracturing and such. And then you can't really see, there's a gray little bar at the bottom, it's commercial use. But that yellow line that runs across the top is an estimate of exempt use. And this exempt use is made up of private domestic wells. And so what I'd like to point out is of the wells that we have in our database, the known wells and registered wells in our district, 90% of them are exempt wells. And these are wells that serve as folks' sole source of water. I would also like to point out that of those 10,000 registered exempt wells, that probably only represents 25 to 30%, as our rules didn't go into place until 2009. Any well drilled before then, registration of an exempt well is voluntary. There's likely about 30 to 40,000 of those exempt wells in our district. And so in 2017, in our 4 counties, we processed almost 1,200 new well applications. In Parker County alone, 623 new well applications. And all those, these are small, you know, 15 to 17 gallon a minute domestic wells. The sheer number of them is what's causing an issue. There's more wells being drilled in our district than any district in the state. Again, they're small domestic wells, but unlike a well even used for oil and gas purposes, once those domestic wells go in place, they're going to be used in perpetuity, right? As long as there's a house there, those wells are going to be used. It's very unique. I spent a lot of time visiting with other groundwater districts. I'm not familiar with any of them that are dealing with this. Representative Burns, I do see this becoming more common in your district as Johnson County is starting to see more. And the reason is and this last panel, or this last group that's talking about decertification of CCNs and public water providers, what happens in our district is rather than having infrastructure in place for new subdivisions, they're just drilling a well and placing a septic system at every lot. That's just what's happening. It's starting to happen in Johnson County quite a bit. And what we're seeing is in our water level monitoring wells within these subdivisions, you're just seeing a constant falling water level. Because especially those folks in the center. And kind of gets into, and I'm going to get back a little bit to that in a second. So that's the issue. The number of wells that we're seeing are really causing, they're our threat to achieving the DFC. It's really not the non-exempt wells, the wells that would be permitted. However, we have spent the last decade collecting data, water level data, data from actual water producers, and we've been spending a lot of time actually developing and about to put into place a permitting structure. What we found of what we consider the non-exempt wells, so the public water supply wells, the wells used for commercial purposes, oil and gas supply, those wells, of that right now, 90% of that use is actually made up of public water supply wells. And most of those wells, most of that use was in place long before our district was created. So we use that term again, investment-backed expectations. To honor that, we are looking at putting in a historic use permitting process for those folks that have the wells in the ground, they have the production. These mostly, and I'd like to also add, so in our district, most of the public water suppliers aren't the large cities. So with the exception of Granbury, which is moving more towards surface water as they're developing a more advanced water treatment facility to treat the water out of Lake Granbury, but Weatherford, Decatur, Bridgeport, Nakona, Bowie, all of the largest cities in our district are all on surface water. The groundwater users are your MUDs, your SUDs, your water service corporations, your investor-owned utilities, and then they're on the east side of Parker County, the Willow Parks, the Hudson Oaks, the Alitos, they're actually transitioning to surface water and getting away from groundwater because they've seen production in their wells that used to make 80, 90 gallons a minute fall to about 40 gallons a minute. Anyway, I'll move on past that. We're looking at historic use. For future non-exempt users, we're looking at, for an operating permit type situation, we're looking at allocating based on the surface acreage owned or controlled. So if a developer is coming in and he owns the land from the beginning, then that helps a lot. But for a lot of them, we would have to recognize the CCN or the service area. And the reason being is, again, these MUDs, these SUDs, they don't have the funds or the land just isn't available to go out and purchase the property. So we're looking at having to actually, give credit to that service area. We are putting in place a process where any registered well, be it even an exempt well, we're going to discredit or discount from that service area for anybody that actually has a well, or if there's an actual permitted well, then that permit would be taken out of the service area. So again, recognizing the private property right, but with the thought that that water provider is actually going to be servicing most of the folks that they're utilizing their groundwater rights, which is, you're absolutely right, below their surface. Moving on, I had one more thing. I guess it didn't make it into this presentation. We've done a little exercise to look at if we talked about the DFCs a second ago. The MAG is the numerical representation of the amount of water that can be produced each and every year out of the aquifer to achieve the DFC. So when we took the different formations within the Trinity group of aquifer, looked at the surface footprint of those aquifers, the acreage of that, and basically came up with a, acre feet per, how many acre feet or what portion of an acre foot per acre could be attributed to those formations under the MAG. What we found was, well, with the exception of one formation in one county, it was all under 10,000 gallons. So we're not even, tiny, tiny portions of an acre foot, 10,000 gallons per acre, a very small amount. So again, you're just having to, based on what the MAG says, based on achieving that DFC, what we're proposing is actually going to allocate much more than that, and just basically understanding that all the folks out there that aren't utilizing that right, but that is their right. And so it's a very tricky situation where we're in there on the outcrop. One thing I'd like to point out that this slide kind of addresses, in recognizing the service area when allocating permits for future use, for future non-exempt users, the last thing I think we as a district want to do is further incentivize developers to just drill wells at every lot rather than put in the infrastructure. Because my fear, the fear of our district, is when you have these developments with these really nice homes and their sole source of water is a well, well, what happens in 20 and 30 years when the production from that well falls to basically nothing? I mean, you've rendered the value of that property to nothing. And if there's infrastructure in place, even if it's a groundwater-based system, if those localized wells that provide water to that system go dry, you've at least got infrastructure in place. And yeah, it's not cheap, but you can run a water main and tap in and provide water to that. So we want to be careful as to not incentivize development to keep just drilling wells at every lot, because if you really push down too hard on future development, that's what's going to happen. And it's all about, I tell the developers in our area all the time, we're not anti-development, we're pro-sustainable development. Because I grew up in that area, I want to see people be able to live there for generations to come. And we do see issues in a lot of our district with wells at every lot. They're already having problems. And it's just going to grow. Every single summer that we have, like this one that was an extremely dry summer up there, it's going to get harder and harder because there's more straws in the ground. With that, I'm happy to take any questions.
Yeah, Doug, Representative Frank has a question.
You've done an excellent job of outlining the problem or the potential problem in the future. What is your proposed solution? Because I guess how many of the homeowners actually realize, I mean, I'm assuming most people realize if they put one well that's where their source of water is, and so they realize a bit the risk they're taking, but what is your proposed solution?
So we're actually proposing right now, as Sarah mentioned in her testimony, we as groundwater districts we can manage this manage this resource through tract size requirements. Right now, we have a 2-acre tract size requirement for any new well. We're actually talking about increasing that to 5 acres because what we found is, for one thing, when you start doing the math, 2 acres doesn't provide enough of that private property right to really sustain a home. 5 acres is more likely, you start looking at actually having enough water. And also, just because, again, the proliferation of wells is just causing such a huge issue. And you're right, a lot of the folks that are moving out there don't know. Most of them have never had a private well, they've never had a private septic system. They're being sold as, hey, you don't have a water bill now. And, we go through this summer and I can't tell you how many calls we got. What am I supposed to do? My neighbor's watering their lawn and I can't even take a shower or brush my teeth. And so we're trying to address that by increasing the tract size and then putting in place a system that incentivizes putting in infrastructure and looking at outside sources such as surface water. We're seeing surface water development of surface water supplies both to our east and west, and I think long term for our district, those are the solutions.
Thank you.
Anybody else have any questions? Doug, thank you very much. Alan?
Good afternoon, Chairman Larson and committee members. For the record, my name is Alan Day. I'm the general manager with the Brazos Valley Groundwater Conservation District, serving Brazos and Robertson counties. We are also members of Groundwater Management Area 12. I've been asked to speak to Interim Charge 3D, which is the consideration of permitting groundwater to public water supply via the from a perspective of a groundwater district that uses a modified correlative or a modified acreage-based system. I greatly appreciate the opportunity to come and explain our permitting system and the genesis of our structure. By the way of background, our district is located over a number of aquifers, 2 of which are the Carrizo, Wilcox, and Sparta. Our counties serve Brazos and Robertson County, and unlike Doug, 98% of our district is dependent on groundwater. Significant amounts of groundwater are pumped by public water suppliers from high-capacity wells in our district. Some of these entities would be cities, City of Bryan, City of College Station, 4 smaller municipalities, Texas A&M University, and 7 rural water supplies with designated service area, CCNs. About 65% of all the water that was produced in our district in 2017 was produced by a public water supply. Our permitting system is a balance of the statutory requirements that we have and also the best available science that will be associated with the impact on our aquifers. The legislature and the courts have consistently directed districts to base their permitting system on the best available science, to consider all the relevant factors in your permitting process, to treat all groundwater users fairly, and protect private property rights. Texas Water Code, Chapter 3611C, currently grants districts the permissive authority to consider the service area needs or the service area of a public water supplier when regulating our groundwater based on tract size or based on acreage. From the inception of our district, we have used a system that requires production-based acreage to be associated with the well. In 2004, our first set of adopted rules, the district required the new wells in the Simsboro Aquifer to have production-based acreage associated with the well. Our district recognized early on that there was a need to protect existing or prior use of groundwater before the district was formed. We've come in and used historic permits to protect that and to protect that investment-backed expectation. That was very integral from the very formation of the district. Our district has used stakeholder advisory committee during that adoption process, of which all groundwater user groups were involved, public water supply included. Everyone understood the importance of that prior groundwater use and determined that historic permits needed to be used in order to protect that investment-backed expectation. Our district uses the best available science as the cone of depression, the effect of the pumping that's going to occur at that well site over an annual basis. What's the impact and what does that annual impact look like? And because of that, we require the entities, regardless of whether it's public water supply or others, to show the legal authority to produce groundwater from that footprint. We have formulas that are based on, that would use spacing for the different aquifers that drive that formula. Our district has never required anyone to own land in order to pump water. They just simply have to prove the legal authority to do so. Public water supplies within Brazos Valley Groundwater Conservation District have clearly understood and have followed the procedures to be able to go out and get those future water needs. We don't have problems. They understand, they follow those procedures, and they've gone and secured those future water needs. So during the last 2 legislative sessions, there's been attempts to mandate, to amend the flexibility that groundwater districts are afforded in 36112. Groundwater districts are consistently told or instructed to treat all groundwater users the same regardless of type or location of use. Attempts to mandate that retail water utilities be treated differently from all other landowners and groundwater users clearly runs counter to and is in direct conflict with proper aquifer management. And in our case, in our district, groundwater management becomes basically unattainable when public water supply, which make up 2/3 of our groundwater production in 2017, don't have to comply with the same regulations as all other groundwater users do in our district. Would be a real issue for us to be able to properly manage the aquifers. Further, allowing rural water suppliers to buy small tracts of land and produce all the water that they need without securing those groundwater rights around from the neighbors around that affected area where the well might be, motivates landowners, those neighbors, to file lawsuits claiming that we're favoring rural water over others and undercutting and compromising the fair share allocation. In fact, this is a real world issue for us in that in Brazos Valley Groundwater Conservation District, we're currently under litigation on this very matter. So this is a real world issue for us. That's why it's so important that we speak to this today. In closing, I want to be clear that we recognize the important service that public water suppliers provide and firmly committed to assisting them with securing those future needs that they might have. I think you'll all agree, as with other groundwater issues, groundwater issues tend to be complex, and this certainly is one of those. It's clear to us that these issues vary from region to region and across the entire state, very complex. This is one of those. This is the very reason that the Brazos Valley Groundwater Conservation District supports maintaining the flexibility in 36116C, allowing the groundwater districts to base their regulation on the best available science, 1, 2, consider all the relevant factors that you should be considering during the permitting process, 3, treat all groundwater users fairly, and 4, protect the private property rights. And we maintain that the legislature clearly struck the proper balance in 2001 for districts to consider the myriad factors that are out there during the permitting process with the shared goal of managing the resource and providing water for Texans in the future. I appreciate the opportunity to come and speak to this, and certainly Chairman Larson would be open to any questions you might have.
Thank you,
very
Alan.
much.
Very informed. If anybody have a questions, Chairman King?
Yes, thank you. Appreciate you coming today. If you don't mind, to the extent that you can, and as briefly as you can, if you could tell me a little bit about that lawsuit that you said, that litigation that was currently going on this very issue.
It basically deals with existing use. When the district came in 2004 and said we're going to have historic permits, we had historic wells, we had existing use, and they've gone back and said that because of that it's not allocating, these wells will be on, most of them are on a smaller tract. These would be the public water supplies. These would be any of those public water supplies. So they may have a very small tract with a large amount of pumping, and the group has come in and said we should be able to offset that pumping. We should have exactly the same amount at a fair share shot as what these smaller tract with a large amount of water being pumped from them. The district, it was clear back in 2004 that you needed to protect that investment-backed expectations. If you didn't, and many went to, say, a correlative system of some type, you were going to be in the courthouse. That was clear. So that's the basics of it, Representative King.
Thank you.
Anybody else have any questions?
Yeah, just a quick question. So you guys have eight 8 aquifers, is that right? You manage eight different aquifers. And so like in my area, you can drill down to the Biloxi, you can go down to the Trinity, and 100 feet to the Biloxi, 400, and just in my little section of Johnson County, 400 to the Trinity. So do you manage, because you said kind of you take into account the down dip and all of that, so do you have different requirements or spacing requirements for different, depending on how far down you drill or which aquifer you go to?
The only difference we have the Simsboro aquifer is our major water producer. So in our formula, when we determine what the footprint is going to be, what the cone of depression or impacted area, it's 1 foot per annual average gallon per minute that we'll use as the spacing requirement.
Yeah.
The minor aquifers are all at 2 gallons of average annual gallons per minute. So we require twice the spacing or twice the footprint in a minor aquifer than we do in the Simsboro.
Okay.
And yes, each aquifer is managed separately, and if you set over an area that has all 7, you have access to all the water under your property, because we deem that you own the water under your property. It is your property right to be able to pump.
Thank you.
Thank you, Alan. Neil?
Yes, sir. Thank you, Mr. Chairman. Thank you, members. My name is Neil Hudgens. I'm the general manager for the Coastal Bend Groundwater Conservation District that serves Wharton County. Wharton County is approximately 1 hour southwest of Houston. I appreciate the invitation to be here today to give you a little information about our district and why we think that a demand-based, reasonable use approach to rules are a good fit for areas like ours that have an overwhelming majority of our permitted production for agriculture irrigation, and where the demand within our district vary between each crop quite a bit. We feel that our rules offer flexibility for our producers, but also provide our district with the tools to regulate and reduce pumping in order to achieve our DFCs. 95% of our overall use is for ag irrigation. In the district, we have rice farming, turfgrass farms, and many different types of row crop farming, including corn, cotton, soybeans, and grain sorghum. The amount of water needed for each of these types of crops can vary from 1 acre foot to 4 1/4 acre foot per acre per year. Some farms have different irrigated crops on the same farm, all watered from the same well. This requires these permit applicants to be very detailed in their application, specifying how many acres of each crop are to be planted. As far as municipalities and industry, which as a whole make up only about 3 to 4% of our overall permitted production, are permitted strictly on a demand basis. The district does not issue permits based on service areas or acres within city limits, but instead issue permits strictly on a reasonable demand. For agricultural permit requests, the Board of Directors adopted recommended amounts to be applied for each different type of crop as the basis for granting permits. For example, with all row crop farming, the board uses 1 acre foot per acre per year as a reasonable amount. And for rice farming, if an applicant plans to farm both the first and second crop, which means after the first harvest of the first crop, the farm is then again flooded for a second crop, that applicant would be granted a 4 1/4 acre foot per acre per year. With these differing demands per crop, a reasonable use permitting approach based on demand is necessary for our area. It would be impractical to apply an approach that would grant the same amount per acre across a district per acre owned. More than likely, that minimal amount that would have to be permitted out per acre in accordance to our modeled available groundwater amount would be an amount that would eliminate most of our local irrigated agriculture, because most irrigators would probably not have enough land to accommodate for their water needs. They would either end up having to lease more land or water rights to meet their current needs, or they would just have to reduce their amount of acres irrigated annually. Our district issues 3-year permits. It's a true 3-year permit, being that a permit holder within the district is not bound to an annualized limit. They do have some flexibility within that 3-year permit term to use a little more or a little less per year during the term, as long as a 3-year authorized amount is not exceeded. When the district approaches the end of each term, water levels are analyzed with the reported pumping data to see whether or not the district should consider any necessary cutbacks for the next 3-year permit term to achieve the DFC. Fortunately, so far, our water levels are not declining. We have not had to enter into a reduction period since the DFC process. Our district does recognize historic use, and we have calculated an historic use amount for all of our historic users. The way we preserve historic use at the Coastal Bend GCD, or at least offer some added protection for these users, is if the district is forced to reduce pumping during a cutback period, the same percentage reductions would apply to all permit holders, to be fair. The only incentive or added protection for historic users is that they would be able to apply this percentage reduction to their historic use calculated amount versus non-historic users that would apply that percentage reduction to their previous actual permit terms, actual use. To ensure every landowner is afforded a fair share during a cutback period, the district will consider permitting based on surface acres owned. Instead of creating a moratorium on any new permitting during a cutback period, the district instead provides people the opportunity to drill new wells to capture the modeled available groundwater derived withdrawal amount. Instead of granting a full beneficial use permit based on the board recommended amounts per crop, the board would grant new permits based on acres within the applicant's control. The MAG-derived amount is an acre-foot per acre amount equal to the modeled available groundwater divided by the total acreage in the county. This at least allows a new user to access some groundwater during a reduction period, even though it's only about 1/4 of an acre-foot per acre. To close, I think it's evident that GCDs are all working towards similar goals in aquifer management, but the differences in the types of uses and the amounts of pumping among districts require that we have the ability to adopt rules that work best for our different areas, even though we may share an aquifer. Thank you for your time. I'd be happy to answer any questions.
Anybody have any questions for Neil? So the aggregate total, how much is historic and how much is correlative on the rights or the permits that you have issued?
Could you answer that question again?
You were saying that you still protect your historic users. What is the balance of it? You got historic and then you've got some other correlative system.
We don't have a correlative system. I was just referring to if we had to enter into a cutback period, any new production during that particular cutback 3-year permit term, if we had new applications at that point. The majority of our users are historic users, so that's something we have to keep in mind when we do decide how much percentage we need to cut back to actually achieve some form of cutback rather than just cutting off a historic calculated amount. We need to be sure that we come up with the proper percentage reduction to make sure we're cutting actual use as well.
And I guess that's where the grind goes on fair share. You got historic, and the Farm Bureau's got members that you have used historic permits to pump water on their crops, and they probably can't demonstrate from any hydrological modeling that there's that water there, but they have it. And I think that's the Farm Bureau. You've got people that fully support the concept, and others, you know, it would compromise their ability to continue to irrigate and get the same yields that they've had in the past. So it's interesting that, you know, from the ag interest, and then the cities themselves. And we've talked about the fractioning, or, you know, the fracture of the system we have right now, and then you'll just have fractional shares under every house if we went that direction. So it's complicated, but it's worth discussing. Thank all of you for coming and testifying. Chair recognizes our second panel. Laura Zant, Kent Watson, and Brent Griffin, and Ronald Gertson. Y'all can come up. Laura, why don't you start us off, if you don't mind? Just state your name and the organization.
Good afternoon, Chairman Larson and committee members. My name is Laura Zent. I'm the Executive Director and General Counsel of Texas Rural Water Association. Can you hear me all right?
Yeah, if you could, yeah, you might just take it off that pedestal if you don't mind. That way you can, yeah.
Okay, is that better?
Yeah,
Okay.
there you go.
Texas Rural Water Association, as I mentioned earlier, is a trade association with a membership of approximately 750 member water and wastewater systems, the majority of which are nonprofit water supply corporations, districts, and small cities. Our members have historically provided reliable and affordable service to rural communities throughout the state of Texas. In many of these areas of the state, our members are the only source of retail water supply for their communities, with no alternative utilities nearby that can provide the service instead. We have come to a crossroads when it comes to the issue of groundwater ownership and permitting for water utilities, and now is the time for the legislature to dictate sound policy for the future sustainability and supply of water for rural communities around Texas. These issues are equally important for all utilities, including larger municipal ones, and I believe this committee should look at these issues holistically, but in this testimony, I'm focusing on the systems and communities that comprise Texas Rural Water Association. The permitting of groundwater for water utilities needs to consider the service area demands of the utility and the ownership interests the customers the utility have in their local groundwater resource. Most of these customers rely on the utility to pump, treat, and deliver their water to them. Texas historically has encouraged regionalization and centralized supply. Does it make sense to change this policy at this juncture? Do we want to create economic barriers to the continued availability and affordability of water supply to rural communities? I had in my testimony, if there were 99 groundwater districts, I heard Sarah say earlier there were 98. So the 98 groundwater districts, according to our research, approximately 22% of them use surface acreage owned or contiguous surface acreage owned as the sole determinant of groundwater protection permit limits. These GCDs treat rural water utilities the same as they treat any individual landowner applying for a permit. Most GCDs, however, recognize that utilities have unique needs due to their obligation to provide water to hundreds or even thousands of customers. These GCDs acknowledge utilities' legal obligation to serve a community and the ownership interests that the customers who are relying on this service have in the groundwater resource. They also balance the interests of landowners' rights to pump their own water within a utility service area. These GCDs provide the model for legislation that is equitable to utilities and the landowners around the state. More than 500 TRWA members rely on groundwater as their source of water supply. According to our research, about 115 of those currently lie within one of the GCDs that limit groundwater allocation based on surface acreage or continuous acreage owned. According to Texas's 2016 state water plan, the population in these counties is projected to increase by about 49% over the next 50 years. And with that population growth comes an increased obligation on rural water systems to supply new customers with adequate water supply. Most rural water systems were found, as we've heard in the last round of testimonies, were founded prior to the existence of the groundwater districts by communities that needed a reliable centralized water service. These communities pooled their resources without the benefit of economies of scale to invest in wells, pipelines, and treatment facilities. And most well production sites were and continue to be less than 1 acre. To my knowledge, and as we heard previously, all groundwater districts have issued historic use permits to utilities that were in existence at the time that the district was created. These permits allow the utilities to continue to pump at historic levels, but do not allow a utility to increase production from the same well as service demands increase without obtaining an additional permit. In districts that base permitting on acreage owned contiguous to the well site, these wells are often not able to be utilized to their full capacity. In these cases, investment-backed expectations have not been met, and it's the customers who have invested in that resource through their rates that suffer. Often property or interest in water rights are not available for purchase adjacent to a historic well site or not at a price that the community can afford. In these situations, districts should at least allow a utility to pump to the well's full capacity based on property or groundwater rights the utility is able to acquire elsewhere within the service area, or taking into consideration the service area needs. Historic use permits also do not extend to a new well if the well for which the permit was issued becomes inoperable. Even historic use permits have been under attack. Last session, Chairman Perry filed a Senate bill that included language that would have done away with historic use permits. This would have had a severe economic impact on nearly every water utility in the state that relies on groundwater supply to serve their communities. This groundwater permitting issue will impact utilities where there is no other supplier to serve the community. Ultimately, this is a debate about who should control the resource. The folks who own large tracts of land in rural areas believe they should control the resource and that everyone should have to purchase or lease from them. We assert that customers of the utility also have a right to their local groundwater resource as residents of the area and shouldn't have to pay exorbitant water rates so that their utility can purchase additional supply from the large landowners. In our view, water should be regulated differently from oil and gas. People are unable to survive without water, and it's a renewable resource. The way it flows, there's often not a set measurable amount under any one person's property. TRWA is also concerned that if rural utilities are required to compete for the purchase of local water resources, they will lose out. They do not have the resources of larger and for-profit entities. A year or so ago, several of our member systems in Northeast Texas, where there's not currently a groundwater district, contacted us because their customers received a letter from a company that offered cash up front to purchase the water under their homes. The utilities worked to educate their customers, explaining that if they sold this resource, the utility would no longer be able to pump and deliver it to them. Some may argue that if asked, utility customers will voluntarily provide a small allocation of their property interest in their water to the utility. This may be the case for some, but as any utility that has worked to obtain voluntary easements from their customers to install or upgrade service lines knows, many will not cooperate in this way. And even if the utility can acquire additional property or water rights voluntarily from some of their customers, will this ownership interest be in a feasible location to drill a well sufficient to supply the community? Now is the time to address this issue before it becomes a crisis and communities are no longer able to enjoy their local water resource at an affordable price. We recommend a couple solutions. First is to require permitting decisions to take into consideration the service area needs or utilities capacity requirements imposed by TCEQ based on the population served. This approach includes subtracting out permitted or registered wells at the time the permit is issued and thereafter. There are no restrictions on a landowner drilling a well within a utility service area, and we're not asserting that there should be. Water utilities only need a small allocation from each customer in order to have sufficient supply to serve them. Another solution that may need legislation to implement and could be done concurrently with the first solution is to create a mechanism whereby utilities can require their customers to execute an assignment or lease of a small amount of water right as a condition of receiving service. At least one city is already considering this type of requirement or possibly having different rate structures for customers who assign their water rights versus those who don't. Cities may have the legal authority to do this, but rural systems, we don't think have that authority. And I'll conclude again, as with the CCN decertification issue, we really appreciate that this issue has generated enough interest and concern to be considered as an interim charge and that you're taking the time to consider it today. We want to again thank Representative Lucio for being a leader on this issue and Chairman Larson for including this issue in the interim charges and for also facilitating a discussion with stakeholders on the issue back in June. And thank you again. I'm happy to answer any questions.
Anybody have any questions? Yes.
Just one real quickly, on the second recommendation, why don't you think the rural water supply companies would have the authority to require execution of a lease agreement or whatever, or purchase agreement or whatever for those water rights?
Well, I say that because there are specific authorities they have in the law, for example, to require an easement as a condition of service, and so they don't have express legal authority. I mean, it's just concerned that it would be challenged if they tried to assert that without the legal authority.
Okay. All right.
Anybody else have anything? Thank you, Lord. Let's go to Kent.
Thank you, Chairman Larson. Mr. Chairman and members of the committee, my name is Kent Watson, and I'm the General Manager of the Wixon Creek Special Utility District located in Brazos, Grimes, and Robertson counties, and we serve a population of over 20,000. Wixon Creek SUD has 16 wells that are permitted in 2 different groundwater conservation districts. And some groundwater conservation districts, as you've heard today, they permit wells based on contiguous acres that the utility either owns or controls around a well site. And some groundwater districts permit based only on beneficial use and do not require acreage when permitting those wells. Wixon Creek SUD operates in one district that requires permits to be issued based on a certain amount of contiguous acres that you must own or control around the well site, and the other groundwater district only considers beneficial use. We prefer a district that permits on beneficial use. In the last session of the legislature, I testified for Representative Lucio's House Bill 1318 that would require groundwater districts when permitting to consider the aggregate acreage owned by a retail public utility and the retail public utility's customers inside the district, and permitted wells could be subtracted from that acreage. We continue to believe that something similar to Representative Lucio's language should be considered in the future. A retail public utility, such as our special utility district, is required to have a certificate of convenience and necessity that is issued by the Public Utility Commission. This is a requirement, a mandate, if you will, to provide continuous and adequate service at all times to the area that the PUC has approved. A utility such as ours, the Wixon Creek utility, has the requirement to provide 0.6 gallons per minute of pumping capacity per connection at all times. With the extensive growth within our utility, Wixon Creek SUD updated our master plan of our utility and determined that we would need 4 new wells in the next 15 years. Based on the requirements of the groundwater district, we would be required to own the land or control the water rights to over 150 acres of land contiguous to the proposed well sites. In November of 2015, Wixon Creek SUD purchased 191 acres of land that would allow us to drill the necessary wells to sustain us for the next 15 years. The purchase cost to the Wixon Creek Utility District was $1,530,000. This is a cost that will have to be recovered through customer rates. Customers of Wixon SUD and other utilities will have to pay inflated water prices when no consideration is given to the acreage that we own or that our customer base owns. After we determine exactly where the wells will be drilled, we will secure the necessary sanitary control easements, strip the water rights off of the remainder of the property, and work with a developer to try to sell lots to recoup some of our investments. We are not land developers and we don't want to be. But rather than pay expensive water leases and be held hostage by large property owners, we chose to make the investment to purchase the property and try our best to hold water rate increases as low as possible. At our utility, we have one well that was permitted by the groundwater district based on previous historic use. This well was drilled years ago with the potential to expand the pumping capacity as the utility continued to grow. This well could be expanded and could pump twice as much water as it currently is permitted to pump, but we only own a small amount of land where the well is located. There are 4 property owners that surround the well site, and we have not been able to purchase or lease additional property rights to increase the pumping. A special utility district such as we are does not have the ability of eminent domain to secure that property for pumping purposes. In October of this year, we will have overpumped our permit. The well will have to be shut down, and our investment is now useless. This appears to be a takings from the ratepayers of the special utility district. Our 191 acres is a mile down the road, but we are not able to increase our existing permit because the 191 acres that we just purchased for $1.5 million is not contiguous to the existing well site. Our water customers are the ones that have to suffer because of these permitting processes. Utilities such as ours are not trying to get rich selling water, but it appears that large property owners are trying to create a market for their water and have convinced a few groundwater districts to establish a permitting process that will accomplish their mission, all in the name of protecting private property rights. Our customers are landowners with property rights to their groundwater. They are not pumping the water that they need. They rely on us, the utility, for the acquisition and conveyance of their water supply. It is not financially feasible for most individuals to drill wells, so they rely on us to do that for them. We would ask that consideration be given to the acreage that we own and the acreage that our customers own when permitting wells. Our customers deserve their fair share of the water they own. We have been asked to provide that water to them, and that is what we're trying to do. Therefore, we would ask that favorable consideration in the future be given to legislation that would provide some relief to water utilities such as ours when permitting wells for the production of groundwater. And I thank you for your hearing today,
and I stand for question.
Yeah, thank you, Kent. Anybody have any questions? Appreciate your testimony. Let's turn to.
Good afternoon, Chairman.
Yeah,
Committee.
Brett, yeah, go ahead.
Thank y'all for having me. I'm Brett Griffith. I'm from Del Rio, Texas, in Valverde County. Y'all were just there a couple of weeks ago. Y'all are following the fish, I think, but
Yeah, you're
anyway, it's a
following
good way
us.
to be. But anyway, I'm a member of the Texas and Southwestern Cattle Raisers Association. I'm also a member of the Natural Resource Committee and the Water Subcommittee, and they've asked me to come here and speak about groundwater rights today. So, as you know, the cattle raisers, they're an advocate for the rancher and landowners in Texas and the Southwest, several other states. And they're an advocate for property rights. They educate and promote good stewardship of the land and the resources underneath. Representative Burns, a while ago, you hit the nail on the head for us as far as what we're talking about. We are for water districts, we are for local control, but it seems that some water districts are set up with an agenda that's not about the property rights or protecting the resource. Sometimes they're set up to stop whatever they want stopped. So that's what we've seen. You know, we would just like to see that every water district recognize and respect the property rights of the landowner, as in the Constitution and the law, as our state constitution says. So that's our position. The landowner and the organization just asks that the landowner be treated fairly and equitably, and I don't think that's an unreasonable request.
Thank you, Brett. Anybody have any questions or comments? Yeah, Representative Frank.
It's a comment, probably somewhat tying the last two testimonies together, because totally agree with what you're saying on protecting private property rights. Also tend to agree with most of what you're outlining in the prior testimony about, you know, if you have land, it ought to be included. The only thing I struggle with a little bit is the seeming disdain for water markets and private property rights in your testimony, not the actual recommendation itself, because I don't think those things are mutually exclusive. I think you can, in fact, even in your recommendation, it respects property rights, but it doesn't appear that some of your testimony does. And so,
well, I hope there wasn't.
That's more.
I hope
no,
you didn't
not
take
your,
disdain
no,
from me.
No, not your, no. Yours was very clear, but I think I don't have a problem personally with what you're talking about in your testimony, but just some of the wording probably makes me bristle a little bit.
Thank you, Brett. Hey, Ronald.
Thank you, Mr. Chairman. Appreciate the opportunity to come and share our perspective. My name is Ronald Gertzen. I am a fourth-generation rice producer here in Texas, and I am an 18-year veteran of this great state's regional water planning process. I am here as a representative of the Texas Rice Producers Legislative Group. The Texas rice producers have a tremendous stake in both groundwater and surface water policy, as you can imagine. So rice must be grown in a water-saturated environment. About half of the 200,000 acres of rice that's grown in Texas is largely dependent upon groundwater as its source for irrigation. 30-plus years ago, it would have been normal for rice producers to be using somewhere around 7 feet or more per acre. There's a lot of water to grow rice. We have managed through a number of means to get that number down closer to about 4, as Neil Hudgens mentioned earlier. For the Coastal Bend Groundwater Conservation District, they're permitting about 4.25 acre feet for rice. Thanks to the application of lots of conservation and huge investments on the part of the producers and landowners, we're down. Now, that sounds like a lot of water, but it's actually not unusual for a lot of irrigated crops to take 4 feet. Even corn can often take 4 feet of water. Now, granted, that water is often coming from deep in the ground, so you don't really see that it's using that water, but yes, that's not unusual. With that 4 feet, we can produce 2 crops of rice here in Texas thanks to a long growing season. The first or main crop is planted in March to April and harvested July to August, and then from the root system of that main crop, we're able to grow a second crop of rice without replanting. that typically yields about 50% as much as the main crop did. That second crop is fairly unique among rice-growing states and enables Texas producers to be very competitive in the world's rice market. Rice producers are nervous whenever the legislature comes into session because there's always the possibility that water policy will be altered in a way that could negatively impact our water availability. We've long been concerned about the pressures being brought to bear by groups seeking to make it easier for landowners to quantify and profit from the sale of never produced groundwater beneath their property. Advocates of this policy often call this a fair share, as has been mentioned numerous times here today. The movement largely ignores the property rights associated with those of us who have, under the prevailing rule of capture, invested heavily in irrigated farming ventures that would be severely negatively impacted by such measures. The rice industry representatives, as well as many other stakeholders, including myself, worked hard in the summer of 2000 in the run-up to Senate Bill 3 to assure that groundwater policy would continue to recognize our historic right to continue capturing the water that made our operations possible. Senate Bill 3 accomplished this by providing the groundwater conservation districts the authority to grant permits based on historic use quantities. Rice producers in particular, and irrigated agriculture in general, are highly dependent upon the availability of groundwater in quantities that, in some cases, far exceed what might be available under strict adherence to a correlative right permitting system, a potential result, a likely result of the application of fair share policy. Let's take my home county of Wharton as an example. Neil Hudgens mentioned this earlier, but I'll go into it in a little bit more detail. Our managed available groundwater is around 185,000, modeled available groundwater, excuse me. It's around 185,000 acre feet. Our county has about 700,000 acres in it. If you do the math, that's about 3 inches of water per acre. There is not an irrigated crop that you can grow with 3 inches of water. Interestingly enough, we have relatively high availability compared to other counties in the state. So you can pretty much assume that anywhere else, if you apply that similar principle of strict adherence to a correlative right system, there would be virtually no irrigated agriculture in the state without those producers having to go out and purchase or rent or lease additional land from which to draw those rights from. Furthermore, in most counties throughout, okay, I covered that, sorry about that. Getting ahead of myself. Rice producers have huge investment-backed expectations that would be lost if they were to be denied continued access to the groundwater upon which their operations have been built. I want to point out here that Bragg Pecan Farm successfully sued the Edwards Aquifer Authority under similar conditions and won the right to recover the investment of the Braggs made in the pecan farm that would not have been able to be recovered through their investments because the permit issued by the EAA was insufficient to irrigate the farm as originally intended for pecan production. Similar situation could happen here with rice production and really with all of irrigated agriculture. The regulation of groundwater in a manner that would remove the future availability of historically used quantities of groundwater from irrigated agriculture would devastate the state's rice industry and precipitate a host of takings lawsuits that could severely cripple local groundwater districts due to their inability to meet resulting financial obligations. In many of the rice-producing areas in Texas, there are no alternative crops to replace rice. And absent the necessary water for rice production, the land would become pasture and lose over half of its value. Additionally, rice producers' investments in specialized equipment, on-farm storage facilities, and irrigation equipment would virtually be erased. The losses could top $3,000 per acre. For a typical 1,500-acre rice farm, the losses could exceed $4.5 million. It may be of interest to note that there is no formal organized group representing the unique interests of irrigated agriculture aside from the rice producers themselves in terms of a statewide organization. And we are not a statewide organization. We admit that. Other farm groups in the state are often dominated by landowners and dry land farmers whose interests regarding groundwater often run counter to those of irrigated agriculture. In closing, I urge this committee to strongly consider the impact of its proceedings on irrigated agriculture. We urge that the ability of local groundwater conservation districts to make permitting decisions appropriate to their unique conditions be preserved to the maximum degree. This includes preserving the ability to issue historic use permits, the ability to permit for beneficial and reasonable use quantities, and the freedom to not utilize correlative rights, especially in those situations where legitimate takings claims could result. Thank you for your attention, and I look forward to continuing to work with you in preserving and protecting irrigated agriculture as a vital natural resource and economic driver in our great state.
Thank you, Ronald. Representative Frank.
I just appreciate you taking time to come testify, and I think you are very wise to be worried when we go into session.
Yeah. Well, I mean, I think y'all encapsulated the issue, you know, from the utilities to the landowners to the irrigated farmers. It's a big issue, and we need to move slowly, probably on a glacial pace, to make sure that everybody's concerns are addressed, because if you do something and it's gonna obviously have an adverse impact on others. And I think the discussion is healthy. You know, the whole fair share concept is something that's used in the oil and gas industry. And as we discuss water, it's a little bit different of a commodity. People live off of it. You can't drink oil, at least yet. And so we'll have to sort through it. But I appreciate all of y'all coming forward and testifying. Thank you. Chair recognizes our third panel, Larry French and Wade Oliver. Larry, you're coming to every one of these, aren't you? Good to have you come down from Austin. Why don't you kick it off, Larry? Yeah, you might just have to take it off that pedestal. You know, you do a lot of karaoke, don't you? Okay, that's what I've heard, so that's great. Yeah.
Okay, is that better?
Yes, sir.
Okay, thank you very much. Good afternoon, Chairman Larson, members of the committee. For the record, my name is Larry French with the Texas Water Development Board. Pleased to be here, and today we'll be changing gears a little bit, and I'll be talking about summarizing some methods and approaches that the Water Development Board is using to quantify the amount of groundwater that can be produced. So I'll have a PowerPoint presentation there. Also, you should have paper copies as well. I always like going through a non-technical Plan B, just in case.
Sure, absolutely.
So while policy and management approaches concerning groundwater have been changing and certainly discussion over the years, the type of data used to estimate how much groundwater can be produced really has remained fairly constant. We've been changing tools, but really when you look at the kind of data that we use, it's pretty much the same. So I'm going to be covering the three aspects of producing groundwater that were identified as part of that definition in the Fair Share House Bill 3028 that was introduced in the last session. So first of all, and this is going to the second slide, how much groundwater can be produced under desired future condition, and that is the current approach that Texas relies on. Local groundwater conservation districts that adopt policy statements that express quantifiable goals for aquifers that are then converted by the Water Development Board into groundwater pumping numbers, or the modeled available groundwater. And these numbers also serve to inform water availability for the purposes of regional water planning. Then next I'll look at how to estimate groundwater that can be produced under various operating and hydrological conditions. This is an approach that the Water Development Board used in the past when prior to the kind of the bottom-up process, when the agency was looking at using available hydrologic data and aquifer properties to estimate how much groundwater could be produced. And then lastly, I'll touch on methods to evaluate water level changes that are due to production of groundwater. So moving on to slide number 3, model available groundwater is, has already been mentioned, is the average annual pumping that will achieve a desired future condition, which is a quantitative statement of what an aquifer should look like at some point in the future. That number is a result of joint planning conducted by groundwater conservation districts that overlie common aquifers. And those districts must consider various factors ranging from aquifer properties and conditions to socioeconomic conditions and private property rights. So how much groundwater can be produced is calculated in most cases by groundwater availability models. These models are regional, they cover large areas, they're developed by the Water Development Board or its technical contractors. And they're developed, these models are developed with a lot of input from local and regional stakeholders. They're reviewed by the public and they're updated whenever possible with available data. So the picture on the left of the slide illustrates the complexity typically of a subsurface aquifer. Now that aquifer has to be approximated and subdivided, sliced and diced into the grids like the picture on the right. That picture is a cross-section from the Carrizo-Wilcox aquifer, and it shows that really there's a different and complex mixtures of sand and shale that have different amounts of fresh or saline water. I should acknowledge my co-panelist Wade Oliver, who I think drew that cross-section, or at least his friends did. But most aquifers in Texas have this level of complexity. A lot of times we show pictures of very simplistic portrayals of aquifers, but they're really quite complex. So our job is to take that complexity and distill it down to 1 square mile grids. And so that really means that when you look at the output of these models, they're very regional in scope. They're not appropriate or useful for like evaluating a specific well field or what's going to happen on someone's individual tract of land, unless of course it's very large. So they're not suitable for evaluating local groundwater impacts. The next slide, slide 4, shows that there are many regional aquifers in Texas exhibit substantial variation so that multiple desired future conditions are often appropriate for the same aquifer. I think Doug Shaw showed a very similar picture of the Trinity aquifer that showed there's water, many aquifers have both a water table or unconfined component in the outcrop and an artesian or confined down dip condition. And these aquifers, even though it's this one aquifer, will behave very differently according to different pumping conditions. So for example, we've observed in deep confined portions of aquifers like the Trinity, which Doug Shaw showed that one map with the very pronounced drawdowns, or the Carrizo-Wilcox, we'll see drawdown in the deeper confined portions, but many times we don't see what we would predict in the shallow outcrop portion. So it's a complex situation, and sometimes different tools are called for to evaluate different conditions. Running models of the GAMs help us evaluate how operations in one part of the aquifer can translate to different impacts in another part of the aquifer. I did say that while the GAMs are regional in scope and not useful for local conditions, many times you can take the GAMs and then apply them and telescope them down into a local, create a kind of a new model based on the conditions and properties that were used in the GAM. So it's possible that you can take a GAM and then kind of rework it and recalibrate it to a local condition with a finer grid structure. The next slide shows a picture of just how complex it can be in a regional aquifer. Took this picture from the lower Rio Grande Valley. We just recently completed a model of the groundwater resources here, and illustrates that at different levels, different depths within that aquifer, there's the distribution and thickness of the sand bodies, which is critical to evaluating groundwater production characteristics, can vary from place to place. So it's vitally important to have a good characterization of an aquifer. So let me move on to the operational and hydrologic conditions. The next slide shows another approach that we've used historically at the Water Development Board to evaluate groundwater conditions. And that is, what do aquifer conditions, or how does the aquifer behave when groundwater is pumped? So this is a very generic cross-section. We've used examples of this before, where our scientists will look at the different geologic features, the geometry of the aquifer, look at the boundary conditions such as water quality conditions, maybe structural conditions that might limit or enhance production potential. And then we can figure out how much drawdown could be accommodated given certain parameters we might look like. In the past, we've certainly considered existing screened intervals of water wells and so forth, and evaluated that. If you look back into many of our historic reports dating back in the 1960s, even through the mid-1990s, you'll many times see in those reports maps or figures that show areas that are favorable for groundwater development. It's been a process that we've used similar to what that slide illustrates. So let me finally, on the third topic, look at the water level changes. To characterize water level changes or drawdown in an aquifer requires that you understand where the water levels are, obviously, before pumping starts. We need to understand the characteristics of the aquifers, including the natural hydraulic gradients, and knowing where the pumping wells are and how much groundwater they're pumping. We can use numerical flow models like the GAMS, but many times a simpler approach is called for what we call analytical modeling, and that's basically kind of a fancy name for describing just using equations or spreadsheets to help us calculate how much drawdown or drainage is attributable to pumping wells. It doesn't have the flexibility that a numerical model might have, but it can be very helpful for looking particularly at single or a few wells at a time. This slide shows a picture from our agency website. I think Doug Shaw mentioned that he likes to go to the 3D model. Actually, I like to go to this one because you can input different characteristics of wells, like a pumping rate, aquifer characteristics such as the transmissivity, which is kind of the capacity of an aquifer to transmit water. And you can do a bunch of what-if scenarios that will give you an understanding of how far a cone of depression may extend out from a well, given different pumping rates, how much time it will take to develop, and so forth. So there's some simpler ways that scientists can also use to evaluate groundwater pumping situations. The next slide shows some simplified examples where analytical modeling or numerical modeling could be applied. On the left side is kind of a generic generic cross-section of water table aquifer, showing a pumping well in the center with water levels lowered around the well. That's an unconfined aquifer where water levels are lowered and portions of the aquifer around the pumping well are locally drained. On the right side, you could have a confined aquifer being pumped where water levels are lowered, but it's really a reduction of pressure and not actually a physical dewatering of the aquifer that's taking place. The aquifer itself remains full of water, and the equations that I just described can be used to help evaluate the area of influence of a pumping well. So an approach like that can be useful for evaluating more local conditions, particularly where you're concerned about the effects of a pumping well on existing wells or neighboring plots of land. Can be used that way. And then finally, in the last slide, that just shows the effect of pumping multiple wells in aquifer, where you have wells that will interfere. Those pumping cones can touch each other and basically overlap, and they can become superimposed, so you can have kind of a cumulative greater drawdown. This is typically accounted for by many groundwater conservation districts in their well spacing rules. Many of them have property line setbacks and production limits to address the kind of situation that you might have here. Again, you can use a numerical model or the analytical solution I described, but you can develop it to tailor it to whether it's a confined or unconfined condition. Sometimes you have to go through kind of a trial and error process for that, but you can achieve maybe an optimal pumping rate that will consider both the existing landowners and neighbors to optimize possible drawdown conditions. So in summary, I've just given you kind of a view of some types of methods and tools that we've used that can be used to evaluate these conditions and how much groundwater can be produced and the methods we use to look at that. So this concludes my testimony, and I'd be certainly happy to answer any questions you might have.
Anybody have any questions for Larry? As always, outstanding. You're like a professor of water. Every time you sit in front of this committee, it's very informative, straightforward. I like you and Doug talking about the confined and the unconfined aspect of it. That's not something that you've seen in a lot of water conferences over the past few years. Y'all are drawn down and looking at the variability of each of those sections. So that's cool. Thank you very much.
Appreciate it. Thanks very much.
Thanks. Wade? You might need to take that thing out of that. Just there you go.
So Chairman Larson, is this working? Chairman Larson, members of the committee, I appreciate the opportunity to be here today. My name is Wade Oliver. I'm a hydrogeologist at Intera Incorporated. We're a private company. We are based in Austin. I work out of our Houston office. And we work with groundwater conservation districts, water developers, water utilities, lots of folks around the state to help them better understand, manage, and develop their groundwater resources. I'm here today not representing any of our clients. I'm here to serve as a technical resource for you, and so I'm not advocating for or against any particular policy, but I hope you find this information helpful as you're working through issues that are inherently technically complex. My remarks today focus primarily on two big questions, and that's what characteristics of aquifers make them more and less valuable, and then how could we distribute availability onto individual tracts. So these are the major aquifers in the state. I'm sure you've seen this map many times. The blue in the Texas Panhandle and the High Plains is the Ogallala Aquifer that I know you're all familiar with. The Trinity Aquifer is in green, stretching from the Hill Country up through Dallas-Fort Worth into to the border with Oklahoma. And then the Edwards Aquifer extends from Kinney County through San Antonio up to Austin. And I'm pointing these out because I'm using them as examples later on. These are the minor aquifers in the state, and these are the aquifers designated by the Water Development Board as generally providing a small amount of water over a large area or a large amount of water over a relatively small area. And I've highlighted the Dockham Aquifer here. If you're familiar with the High Plains and the Texas Panhandle, you may have heard the Dockham referred to as the Red Beds or the Santa Rosa. So that's the unit that we're talking about here. Chairman Larson, I'm glad you mentioned the unconfined and confined portions, because apparently I'm beating a dead horse here.
Yeah, you're just the third person. Unfortunately, if you were the first, everybody would go, wow, that's pretty crazy. But Doug stole y'all's thunder, both of y'all.
We should have coordinated better, but that's okay. So I won't dig into it too much, except to say that the characteristics of an unconfined and a confined aquifer strongly influence the way that it responds to pumping. And if we go to the next slide, you'll see that it's very common for one aquifer to have areas that are unconfined and different areas that are confined. So the Ogallala is your classic unconfined system. The Dockham is predominantly confined, and then the Trinity and the Edwards are a mix of both. And so these are things that groundwater districts have to consider when they're managing different areas of these aquifers. So this table is a list of characteristics of aquifers that I've pulled together that in my mind influence the value that landowners receive from the groundwater resources beneath their particular plot of land. I've mentioned confined and unconfined. Rock type is important. Geologists, we call it lithology. Whether you have sands and gravels or sandstones and clays or limestone, all influences how much water you can produce. That ties into the permeability of the aquifer. That's a term also used in oil and gas. Whether it's high and water can flow very easily, or whether it's pretty tight and it can't. Another characteristic is what we call primary or secondary porosity. So primary porosity is what you would think water flowing through sand grains or through gravels. Secondary porosity is water flowing through fractures or through cavernous porosity, like you have in the Edwards aquifer. That's a karst aquifer. Water quality is really important. So is it fresh, is it brackish, is it a mix of the two, depending on where you are? That strongly influences the value. Another one I want to hit on, available drawdown. It's analogous to the water level, but it strongly influences not how easily water can flow through, but your ability to create a slope in the water level to drive water towards your well. It's your ability to induce movement of water in the aquifer towards your well. And that's a lot of the confined aquifers that we have, their value is tied up in the fact that they're confined, the water level is above the top of the aquifer, and producers can draw the water level down a lot to drive water towards the well, and in a unit that's otherwise not nearly as permeable as, say, the Ogallala. Recharge is important. Storage volume is a factor as well in some aquifers. And I bring all that together to say that if you look at the bottom of this table, it's the volume of water estimated production from that aquifer in 2016. So you can see the Ogallala has far and away the most production of any aquifer in the state, almost 5 million acre feet in that year. The Dockham sits in the exact same part of the state and actually has a higher storage volume than the Ogallala, but has 1/100th of the production because all of these other characteristics make it so that it's less attractive to the landowner. To drive this point home, I won't dwell on this side, but to drive this point home a little more, you can see that there's not a correlation between how much water is in the aquifer and how much landowners choose to produce from that aquifer. So to orient you to this, along the x-axis, you have the total storage in the aquifer. This is from the TERS estimates developed by the Water Development Board. Along the y, you have the estimated 2016 pumping, and so each dot is one aquifer in the state. The Ogallala has kind of a moderate volume, but in an extraordinarily large volume produced. Gulf Coast and Carrizo Wilcox have quite a bit of production, but an extremely large volume. And then I'll draw your attention to the Edwards, has a very small volume, but still a lot of water produced because of its unique characteristics. So it's really all of the characteristics taken together that drive groundwater availability, more so than just the volume. So if I'm going to distill these down into a few points, what matters is how easily can groundwater flow, how steep of a water level gradient can you produce and maintain, and then is it worth it? And by is it worth it, I mean, is the depth of the aquifer something that you can drill to cost effectively? Is the water that you produce usable for your purposes? This is the calculus that people go through when deciding whether or not to drill a well. So we have a process in place for determining availability. It's the joint planning process, the setting of desired future conditions, and that process takes into account all of these factors and brings into the fray the groundwater availability models to come up with an availability for the aquifer as a whole. And so the question is, how do we distribute that onto individual tracts of land? Conceptually, one way is to take that availability and spread it out spatially. And there's pros and cons to that approach. The pro is that it's consistent with the big picture. The con, as several people have mentioned before, is that you don't get a lot of water per acre, and so some folks are not going to have what they need. A logical alternative to that approach, and by I mean logical, I just mean you can look at it in a different way, is to start with the allocation that you think makes sense, like 1 acre-foot per acre, and then back out availability the other way. And just by way of example, the average county in the state has 1,000 square miles, 640 acres per square mile. So the average county in the state under this second approach would have an availability of 640,000 acre feet per year.
Yeah, I think you got to switch the slide, yeah. There you go.
Thank you.
Yeah.
Now the arrows, yeah. I appreciate that. So for context, 640,000 acre feet per year is an extraordinarily large volume of water, and it's 10 plus times as much as most counties are producing right now. And if everyone produced their right to produce under that scheme, the system would quickly crash. So something to consider as you're going through this.
Yeah, you're on that slide now, yeah.
So this is a map of the modeled available groundwater for each county from the last round of joint planning. It ranges from less than 3,000 acre feet per year in some counties to over 100,000 acre feet per year. If you go to the next slide.
Were you telling yourself to go to the next slide?
Apparently, I didn't hit a button, so there's a ghost doing this.
I like that.
If you divide that out by the area of the county, though, you'll find that availability goes to just over 1/10 of an acre foot per acre to less than 1/100th of an acre foot per acre, depending on where you are. So to address the concerns of some folks that have commented earlier today, I took the area of CCNs across the state, estimated the demand in each of those CCNs based on the population, and then and determined what fraction of that demand the MAG would meet. And that's what this figure shows. And so for the most part, and with a few exceptions, the MAG is significantly below what the estimated demand would be in each CCN. And so I offer that to you, not advocating for anything, but as the discussion has moved towards, if we allocate on an acreage basis and then we credit the area, the service area, such as a CCN or a municipality, the assumption there is that that's a fix that addresses the concern. And I think in a lot of cases across the state that will still not allow for sufficient water for that CCN or that utility to meet their obligations to supply water.
That's a great slide.
So I appreciate the opportunity to be here today. I'm happy to be a resource now or in the future and take any questions.
Anybody have any questions for Wade? Great perspective, drill down on it, on availability and demand, in the areas that we're talking about today. So appreciate that very much.
Absolutely.
Thank you. Yeah, Chairman Lucio.
I just wanted to apologize for stepping out for a second. It's very rare that I get an award, but I was receiving an award today at lunch, an Educational Excellence Award. So it was hard to pass up. It was in front of my wife and my parents, who seem to be pretty hard on me lately. So it was nice to share that with them. And it's the day you're here, and I sincerely apologize. But
Oh, no.
Mr. Chairman, thank you for your understanding.
No, appreciate you hosting us. Thank you.
Yes, sir.
Thank y'all, gentlemen. I appreciate it. Going to our last panel, we got Morgan Johnson and Brian Sledge. Brian, why don't you go? Morgan, you go ahead.
Okay.
Brian wants to defer to you.
Good afternoon, Mr. Chairman and committee members. My name is Morgan Johnson, and I'm an associate at the law firm of McGinnis, Lockridge, and Kilgore in Austin, Texas. Today, I'm not here representing any specific client, but was asked to present an idea that Russ Johnson, a partner at McGinnis, that I work closely with on a lot of groundwater issues, real property right issues, landowner issues, businesses, a variety of clients. We work together closely on the availability of water. Before I would go into the testimony today, I first want to specifically discuss the language that we've already just mentioned multiple times already today, and I believe what has occurred, the unintended consequences. Specifically, Section 36.116 of the Water Code states that groundwater districts may consider the service area or service needs of a retail public utility when the utility has applied to the district for a production permit. Because the language in the statute uses the term may rather than the term shall, it leads to some uncertainty for those utilities that are applying for such permit, especially if the district allocates that groundwater production based on acreage owned. Since most utilities, as we've heard today, don't own a lot of acreage, the utility is left with either leasing property or, as Braz has discussed today, entering into contract to purchase property within the area of the district or finding another supply of water and potentially running into capacity issues. The idea that Russ Johnson and I have both discussed and kind of just tossed around with one another that I would encourage questions or more discussion about is to amend the statute in multiple ways, but the two main being, one, to require districts to consider and take into account a utility service area. We would also require that the utility have, once, if they were issued a permit, have that permit potentially amended every year on an annual basis depending upon the production permits that the district granted that year. And there's several caveats to this, I guess you would say, idea. When a utility applies to the district, they would need to be able to show their exact service area. Now, obviously, some service areas, like for a municipality, they can change. It depends on if someone in their ETJ or someone outside the ETJ requests service from that utility. However, the utility, though, would be their burden to prove their service area. They would also have to show, when putting upon evidence of their service area, that they overlie the aquifer in question that they would like to drill their production well. Second of all, another caveat of this would be that the district service area would be reduced based upon the landowners within the service area that have production authorizations. This means that the authorization will account for the land supporting those active production permits and any permits issued by the district in the future. So on an annual basis, how that would work is, say a permit was issued, and say maybe the term of that permit was 5 years. On an annual basis, that permit could be adjusted and decreased down depending upon how many landowners in that service area of the utility apply for and receive a production permit. The last caveat would be that the district could not use the location of a utility's production well to preclude the drilling of, or to preclude the issuance and the drilling of a landowner's production well. And the idea behind this scenario is that you are attempting to balance the landowner's right to produce water that they own, that it underlies their property, with the fact that the utilities, as we've heard today, many of them have the obligation to serve, and they're looking for ways to find water. And this would, in a way, balance, and you would look at it almost like a pie, with the service area being the pie. And the more production permits that are issued by the district on a yearly basis would then reduce the pie, quote unquote, of the utility service area that would be the foundation of that production permit. And with that, I would be open to any questions.
Anybody have any questions? Ryan?
Thank you, Mr. Chairman. Do I need to hold that closer, or am I good?
You're good. Well, I can hear you.
They say closer. Thank you, Mr. Chairman, members of the committee. My name is Brian Sledge. I'm an attorney with the Sledge Law Group in Austin. I'm cleanup batter here today on the invited testimony, and I'm going to try to focus on the big picture.
Hit a home run then.
I'm going to. We're going to talk about batting averages a little bit. My opinion, is that we're past the point in this state's history that we should be changing any of the groundwater allocation tools in Chapter 36. I think changing the financial provisions, transparency, procedural, planning provisions, lawsuits, appeals, attorney's fees, whatever, are all right for the legislature's consideration. But any fundamental change to the groundwater allocation tools in Chapter 36 at this point in time, whether that's by removing one of the tools or mandating that all groundwater conservation districts across the state utilize a particular tool in their regulatory system, I think would be disastrous to this state, to the economy, and to the investments of landowners, businesses, retail public utilities, industry, private landowners, who have already made substantial economic investments in the permits that have been issued under the regulatory systems that have been in place under the statutory scheme as it currently exists. There are a lot of great ideas that the legislature has floated around the past couple of sessions on groundwater allocation doctrines and how they might be applied statewide. And they would have been great ideas to implement in 1949 when we were setting up this regulatory system. But today, any fundamental changes to those doctrines would just have economically disastrous consequences. It would be as if you came in today and went into Chapter 11 of the Water Code and said, you know what? I don't really think prior appropriation system works out in surface water for everybody like it should, because we hear a little gripe here, or a bad situation there. Let's just do away with prior appropriation and go to something different. If you can imagine how disastrous that would be for the investments that have been made under the prior appropriation system across the state, it would be no less disastrous to make fundamental changes at this point in time to our groundwater allocation doctrines. The way that the legislature set up Chapter 36 originally, and the way it has always been, is to have a permissive set of regulatory tools in the statutory toolbox, and to let local groundwater districts develop and implement a regulatory and permitting system that makes sense and protects the investments and the local property rights based on their local hydrogeologic conditions and the way that the economy and the communities have developed over those aquifers. And that necessarily requires the utilization of different regulatory tools, not only across different aquifers of the state, but also across different areas of the same aquifers. To come up with a set of rules that would work for Mr. Gertson and his rice farmers over the Gulf Coast aquifer and think that the same set of rules and regulations would work out in Harris County is just nuts. It is. And for the legislature to come and force that after the fact, when billions of dollars in investments have been made, counting on the stability of the regulatory systems that have been adopted under these tools that you've given these districts to use, it would just be a disaster. And whatever good can come from it, it could not be justified from the bad that it would cause. And furthermore, I don't think there's any need to make any changes. I think one of the biggest misconceptions throughout the groundwater industry and in the legislature is that somehow the Day case called for the legislature to come take action in some way to implement it. It did not. I'm pretty sure that Chief Justice of the Supreme Court would agree with me on this, because I've heard him say it multiple times. Determining what a fair share is, determining the nature of the property right in groundwater is exclusively the purview of the judiciary. After they came out with the Day case, I heard Chief Justice Heck say, he found it interesting what the legislature did in 2011, explaining what it thought the nature of the property right was in groundwater. It was interesting. It was somewhat instructive to the court, but it's exclusively the purview of the judiciary to decide that.
Brian?
Yes, sir.
May I stop you? The Supreme Court says it's their job to determine what's a fair share in groundwater.
Yes.
Good definition.
You get to determine, you as the legislature get to set up districts. You as the
It's just
legislature.
every time I've seen the Supreme Court, they say really that it is our job, and I'm not saying we always do it well, to make groundwater law,
To make what?
to make the groundwater law.
Oh, it's clearly, and the court has said it without
Yeah,
question.
they begged us often.
No,
do a better
it's
job.
clearly, and the court has said it in every opinion that it's mentioned the issue, the legislature's duty under the Conservation Amendment to set up regulations, and in this case, groundwater districts, the way it's been set up, to define the tools, the finances, the planning, the permits, systems, and the legislature has done that. But fair share itself is not an amount to be defined or a term to be defined either by the judiciary or the legislature in some way that applies equally across the state and makes sense for all landowners in the protection of their constitutional interest in their property. It is a concept to be determined by the judiciary as applied against a particular landowner and their particular circumstances under a particular regulatory system. It's not a concept to be defined by anybody on a statewide basis.
But we determine the regulatory system, right?
You can determine the regulatory system, and what I'll submit, and you have, and you have.
So you laid out your argument very well, and by and large, I agree with you. But here's where I'm conflicted, genuinely conflicted. I'm not one to try to change the rules of a game after we've started playing the game, right? Which my daughter loves to do. She's very good at compelling her argument too. But what happens sometimes in our system, and why I think we continue to get elected to go back to Austin, is we have sometimes very old statute, very old rules by which we play by, that were formed at a time where they did not anticipate the conditions of which we are now experiencing today. And it's very hard, like you say, to go back and change the rules after the game has started. But at the same time, it's also very hard to deal with all these unforeseen consequences when these rules were established well before we ever were going to experience the growth in our state that we're experiencing today. So we talk about property rights, we talk about property owners' rights, and depending on the context of which we discuss those are considered held very sacred in our state, right? Property rights, we're a property rights type of state. But then we have some property owners that are over multiple districts who are living in this nightmare that we did not anticipate in the 1940s. So I hear you, I do, and from where you're sitting, that is the argument you should make. No doubt about it. But from where we're sitting and what is expected of us, it's not that easy to use that as the golden rule. And so that's why these conversations, when you say end a conversation, I appreciate where you're coming from. I do. I try to use that argument with Olivia. Somehow she keeps talking. That's why I love serving on this committee.
Well, I get it, and I've been hanging around with this committee in one form or fashion for the last quarter century.
You've forgotten more water law than I know, so I appreciate that.
But I know how folks want to run to the Capitol to solve every groundwater problem they have, any water problem they have. They do that. And the Capitol has responded accordingly and done some great things. I mean, where groundwater law is today, what is expected of districts to know why it is that they exist and what they should accomplish, the joint planning that occurs over common aquifers, the tools in the toolbox that have been given to them, the interpretation of how they can permissively, lawfully utilize those tools through the limited case law that's developed over the last few decades. Those are all great things. But the question now is, what does the legislature need to accomplish? If you looked at what the problem is that's still out there, are groundwater districts doing a good job? Well, if we used the number of lawsuits and regulatory takings claims that have come out as a metric, they've been doing a phenomenal job. because you literally have a handful of those over the last 2 or 3 decades compared to tens of thousands of permits that have been issued. But I would submit to you that if the legislature now goes and tries to make a change, not anywhere else in Chapter 36, but to the groundwater allocation tools, and pull one of them out, or say that every district has to do a particular thing on one of them, like this service area issue, whether you mandate that they all do it, as some of the stakeholders are asking you to do, or you forbid that any of them do it, as some of the stakeholders ask you to do, will cause so many more takings claims and such economic chaos across the state compared to what's currently happening that you really got to ask yourself whether you want to go down that path. You know, I've got districts that utilize surface area for retail public utilities. And the great concepts that Morgan just threw out, that Russ is discussing, you know, we've got rules that we're looking at doing that. I sat down with Representative Burns last week about the rules that are fixing to go into place up in his area across the 4-county region. That's exactly what we're doing. To ask somebody like Terry Kelly, who's one of our constituents, that he needs to go and buy up, when he's looking at thousands of quarter-acre lots, that he needs to go buy up that land, it would just be absurd. I mean, first of all, looking at Wade Oliver's things, we got about 2,000 gallons per acre is what Mother Nature's given us under the MAG. If he had to go do 20,000 individual landowner transactions, real estate transactions, and all the cost involved with that to lease up somewhere, you know, who would pay for that and who would benefit? His customers would pay for it and his customers would get the money. It's just absurd to think that you would make somebody go through that in a big, densely populated urban and suburban area like his, and we're not going to ask him to do it. But what we are going to do is if an individual landowner comes in and applies for a permit within his CCN, we'll take the acreage associated with that permit, give it to that individual landowner, and take it off the table of what he's able to use. It makes sense there. But it may not make sense in other places. To impose it in some areas would cause takings claims and injurious impacts to property rights. To not allow it in others would cause the same thing. And if there's nothing else I can get across, it's the concept that it seems unsettling. It seems unsettling to think that different districts impose different regulations over the same aquifer and that can somehow be fair. But the truth is, if you look at it in the trenches, on the ground, that to try to impose one common set of regulations in all areas across the state, or in all areas over the same aquifer, would necessarily cause more takings claims and more, fill the courthouses with trouble than what's going on right now. We're just past that. Your kid can tell you, you just can't change the rules of the game at this point in time. And as much as the legislature doesn't want to hear that it is not, under the Constitution, the arbiter of determining what a fair share is, it's something you need to hear because it happens to be the law. And it happens to be the way things are under the Constitution. That is the purview of the judiciary, not the legislature. You can change the regulatory tools still. That's squarely on y'all. You can change how planning is done, how groundwater is managed. You can change the way it's regulated. That's on y'all. But however you decide it should be regulated, results in a compensable taking because somebody's not getting their fair share of the resource under their constitutional rights is squarely the question of the judiciary, not the legislature. And I'm just saying, if you make big changes at this point in time to the way, to the tools that you have put out there, that in most areas of the state are well settled. I mean, you don't hear from 95 of the 100 groundwater districts in the state because their permitting systems are settled. The permittees, the landowners, the cities, the farmers, the oil and gas folks, whoever it is, they're all comfortable with it. Their investments have been made, and you won't hear from them unless you come and tinker with that and topple those regulatory systems, which, whether it's in the guise of trying to be more protective of private property rights or trying to have common rules over the same aquifer, however it is that drives you to get there, if you go there, it will be more trouble than it's worth. I'll submit to you. I know that Representative Lucio and Chairman Larson have spent a lot of time with the stakeholders trying to reach some consensus decision on this service area issue. Some folks want you to do it. Some folks don't want you to be able to do it. I'll submit to you that you just shouldn't tinker with it and leave it as it is. We fired up the TWCA Groundwater Committee again. We're going to have a subcommittee that looks at this issue just to see if anybody can think of something outside of the box that hadn't come to y'all in your endless stakeholder efforts. And if we come up with that, we'll bring it back to you. But if we don't, I'd submit to you to not tinker with it, because somebody, a lot of somebodies, will probably have big injury to their private property rights if you force it statewide one way or the other. I'd be happy to answer any questions.
Always entertaining. Always entertaining. Yeah. Anybody have any comments? I believe legislators believe they write the law. They don't believe judges do. And I think that's the feedback you're getting from the three over here on the left, is take exception to comments that the judiciary should legislate.
I'm not suggesting that judiciary should legislate. I'm just saying that fair share is not a concept that is to be defined or legislated. Fair share, and whether someone has received their fair share of their constitutional rights, is a landowner by landowner decision that is made by the judiciary. Y'all legislate, y'all create the laws, but whether someone receives their fair share is a question of how they were treated under the laws you create. And that's a question that's left to the courts.
All right. You good with that?
Well, lawyers are going to get a lot of money, I guess.
Yeah, that's true.
My colleagues are going to get paid.
But we're not saying a whole lot of cases. We're just not.
So should we wait until a whole bunch of people are in harm's way before we make a decision? So
What decision is it that you could make? I guess that's what I'm asking. Not that I get to ask the questions.
If it trends that as we get more densely populated, that water suppliers have to, and you know, because there's freedom and many choices of which you can assign water. But if it trends that you have, it's going to be per the surface property that you own in proportion to that, and you're going to burden municipal suppliers with having to buy acreage in order to get that water rights, and that becomes more prevalent when it doesn't make sense, and that is an additional expense on the ratepayer. At what point do we say, okay, well, now it's egregious enough? It's either egregious or not egregious, right? I mean, we either act or don't act when we see something that is trending. So we're like, oh, well, that just happened in an isolated incident, so we're not going to make it a issue. I hear what you're saying. I do, and I don't want to have a knee-jerk reaction when it is an isolated incident. But at what point is it no longer an isolated incident and people are responding in a way or regulating in a way that doesn't make sense?
But I don't know how you approach the analysis of that on a statewide basis. I just don't know that it lends itself as being capable of analyzed
so we're
or
going to kick it
approached
to the
on a
judiciary.
statewide basis. Because look at everything that's happened at West Texas. You know, they almost all of them in West Texas, the groundwater districts, had a surface acreage-based system. The retail public utilities out there operated under a model because there were huge tracts of land available with groundwater rights where they went and leased those up. You look at some of the areas of the Metroplex where I have clients. What I'm saying is to force that on West Texas at this point in time would probably cause a takings because of the investments they've already made. To disallow it in the Metroplex area would probably cause takings. I just don't see how you can come up, not because who you are, I just don't think the problem lends itself to a statewide solution. The problem lends itself to, as applied to me, guess what? You know, I mean, districts and landowners and stakeholders work on these things together, and they typically work them out, which is why you don't see a high number of cases. They work them out in a way that makes sense in the local economy with a local resource, and you're just not seeing a huge number of cases there. And that's not to say they don't come up, but when they do come up, there is a remedy available for those folks, and it's to go to court and to say, as applied to me and my constitutional private property rights, this district overstepped its bounds. And, you know, if they've adopted rules that don't comply with the legislation that y'all have created if it's outside of the scope of what you've authorized under Chapter 36, there's a judicial inquiry available for that. That's what we're seeing in Lone Star right now. We have a claim that that's happened. We'll see how that turns out. But as applied to fair share, which is, as this district's rules were applied to me as a property owner and my right to a fair share, my constitutional right to a fair share of this resource, this common resource, it almost always works out. But if it doesn't, I do have a right. And it's a right to go to a district court judge and say, as applied to me, this has resulted in a compensable taking of my property. And I need to be made whole. That's what it is. I just don't know how you can solve that statewide.
Either way, we're going to end up in court.
Oh, yeah, you're right. Somebody will challenge it.
Either way.
Thank you, Brian.
Thank you.
That ends our invited testimony. We're going to go to public testimony. We have some witness affirmation forms here. If anybody wants to sign up, you need to fill one of those forms out. I think we've got, what, 10 witnesses? So Joe Jones, you come up, state who you're representing. Came a long ways from Gatesville, Texas, huh?
Yes, sir.
That's great.
My name is Joe Jones. I'm representing Coryell City Water Supply District. Coryell City Water.
Why don't you grab one of these mics right here?
Yes,
or is there one in front of you? Okay, there you go, yeah. Just hard to hear on that sound system.
I'm Joe Jones. I'm here representing Coryell City Water Supply District. Coryell City Water Supply District distributes water over to 1,900 homes over 4 counties. We have one well in operation right now, and we pay a landowner $11,550 a year for water rights for that, to be able to pump water out of that well. When right across the Farm to Market Road, there's several hundred acres of farmland that have been offered to us at no cost to us to use for the water rights. But under the current regulations, we can't use that land because it doesn't directly border the land that our well sits on. It's 100 feet across a road. And that 100 feet cost us $11,550 a year. We do supply, water to a lot of people. Everybody around that well is on our water. The people that we pay for water rights are supplied water by us. So I don't know what the answer is, but that's all I have.
Yes, Chairman King.
Thank you. Appreciate you coming in, and we always appreciate the folks from the public sector that come in. So the 200 acres that's across the road, does it have a well on it now?
No, sir, it does not.
So if you were using it, how would you use it?
Oh, we would just use it for water rights.
Right, that's what I assumed you meant. So you'd have that 200 acres worth of water rights.
Yes, sir.
Does that groundwater district, how do they determine their water rights? Historical use or by the acre?
By the acres that we either own or lease.
Okay. Thank you.
Yes, sir.
Thanks, sir. Appreciate it. Ronnie Skirek? Sirik, okay.
Is that on? Yeah. Okay. My name is Ronnie Skerrick. I'm Vice President of Menlo Water Supply Corporation. I would like to address pumping limits set by Groundwater Conservation District on one of our 2 wells and the impact it has on our system. Menlo is a small rural water supply corporation. It's located about 20 miles north of Waco.
Yeah, there you go.
There we go. Our service area is primarily in Hill County, covering about 35 square miles, with 45 miles of pipe supplying 190 meters. Probably one of the smallest companies here today. We supply 12 to 18 million gallons per year, primarily to rural households and family farms. We don't try to make a profit on the water. We strive for a reliable, low-cost water supply. Our losses are very low and have averaged only 8.5% in the last 12 years. Our board is a working board. Our 3 part-time employees are paid less than a total of $1,000 a month. All of our water supply comes from 2 wells in the Trinity Aquifer. Our number 1 well in Hill County was drilled in 1964, making it over 50 years old now. It falls under the jurisdiction of the Prairie Lands Groundwater Conservation District. Prairie Lands does not limit or restrict pumping amounts on this well. Our number 2 well is in McLennan County, was drilled in 2005 at a cost of almost $1 million. It falls under the jurisdiction of the Southern Trinity Groundwater Conservation District. However, Southern Trinity has placed pumping limits on this well, which can greatly impact us in the future. When the number 2 well was drilled, one design criteria for us was to be able to increase its production over time when the older Hill County well declined due to age and well design. Because of permit limits, this plan is no longer realistic long-term. We designed the facility for a maximum pumping rate of 300 gallons a minute and installed a pump rated at 140 gallons a minute. But we ended up with a permit pumping limit of an average of less than 15 gallons a minute. When Southern Trinity was established, its rules required that we apply for a permit at a cost of $1,000 and pay a fee per gallon to continue operating the well. Its rules also require that pumping limits be placed on the number 2 well based on the highest year of a historical 10-year period. Being a new well, we only had 4 full years of history. So in 2010, our maximum annual permitted amount for our number 2 well was set at only 7,725,300 gallons per year, which is less than the average of 15 gallons a minute. There was no grandfather clause available for this new or for a new or an existing well. So when we planned for and drilled the well, there was no way we could have foreseen this type of future restriction. This permitted amount does not allow for any system growth, particularly when we have no other water source other than the 50-year-old well. Only 4 years of history was not representative of our needs for a well that could easily last for over 50 years. We easily exceed the 7.7 million gallons per year amount and have done so in 4 of the last 7 years, and we'll exceed it again this year, 2018. But we were given a temporary solution to the problem by Southern Trinity. In 2013, they revised their rules to allow water supply corporations to apply for a non-historic permit to pump water above its historic permitted level. The cost of the permit was another $1,000 and required an engineering study be conducted to look at supply alternatives. An engineering study that cost $5,000 proved what we already knew, that there were no alternatives available. There is insufficient lake capacity near our service area. Southern Trinity granted us a 20-year permit for an additional 11 million gallons per year to be pumped from the well. The problem we now face is that the 11 million gallon permit is only good for 15 more years. Through the year 2033, we have the uncertainty of what will happen now and with what will happen in the future with no change in foreseeable alternatives. Southern Trinity also has the right to reduce that permitted level before 2033. We don't know who will be on the board of Southern Trinity at that time and whether another non-historic permit will be available or whether we will have to curtail supply someday. At that time, it's going to be irrelevant that our historic permit was only based on only 4 years of history on a new well. But one of our dilemmas now is, what do we tell someone who applies for a new meter? That we may have to cut your supply in 15 years. During the permitting process for both permits, curtailments of pumping were discussed extensively by Southern Trinity. If curtailments were going to be necessary, Southern Trinity discussed reductions in pumping amounts without consideration for end use, or purchasing water rights from another company that had excess rights. A residential meter could be curtailed or see higher cost even if a golf course was getting water if it happened to have a permit. We would like to stress that curtailments in pumping, if they are necessary in the future, be based on end-use priority like the natural gas and electrical industries. For example, a residence, a hospital, or a nursing home would be a higher priority to receive water before an industrial, commercial, or golf courses. And I don't want to make anybody who likes to play golf mad at me. Additionally, Southern Trinity does not address in their rules how to handle water supply corporations that have wells in more than one district like Menlo. Because Prairie Lands does not restrict pumping levels on our Hill County well, this is not a problem now. But there can be a number of complicating factors in operating the wells in more than one district when both districts have limits, such as which county the water is pumped, which county the water is consumed, different rates for different customers, and addressing different or conflicting restrictions from two groundwater conservation districts. This could cause unnecessary changes in the operation of multiple wells, even if they were coming from the same aquifer, just to satisfy permit restrictions. I appreciate the opportunity to address you all today. I'll be happy to answer any questions if you'd
We
like.
appreciate it, Ronnie. Anybody have any questions? Thank you very much. You defined the issue pretty well. Greg Ellis.
Thank you, Mr. Chairman. Members, I'm Greg Ellis. I am here today on my own behalf. I do represent a number of groundwater conservation districts across the state. I'm not speaking on behalf of any of those districts today. I did want to dispel one rumor. I did not argue the original East case to 1904, but I did make an argument in 1993 in the bar shop case that the Supreme Court should hold that there's not a vested right to a certain amount of groundwater in the ground prior to capture. I lost that fight in 2012 with the Day case, and as a result, I hope you've heard what I hope the impression you've gotten from today's testimony is the type of tightrope that districts are now having to walk to avoid takings litigation and takings claims. We have three basic areas that cause us problems here. We have physical problems with the districts, we have the property rights issue, and then we have legal rights issues. Although we can determine the size of an aquifer, we cannot fully determine the amount of groundwater that may be captured. The TERS, the Total Estimated Recoverable Storage, as developed by the Water Development Board, used an assumption of anywhere from 25% to 75%. That's kind of a 50-50 proposition. That amount changes from month to month or even day to day as aquifers recharge and discharge. Aquifers also have different thicknesses, transmissivity rates, and storativity. The typical groundwater model uses about a 1 mile square cell, an area much greater than some continuous aquifer conditions. Unlike oil and gas formations, most aquifers can, over time, recharge and replace any amount of groundwater withdrawn. Instead of calculating the size and saturated thickness of a formation, groundwater regulation requires calculating the storage and the additional recharge along with the discharges to surface streams to springs. My recommendation today is that the legislature charge the Water Development Board with assessing the amount of perpetual yield of every major aquifer, so we have that as a second bookend to compare against the TERS. The property rights problem include, really what we have here is a battle between those who want to capture the groundwater versus those who want to store that groundwater for future use or those who want to maintain static levels so their well will be continuously productive in perpetuity. Oil and gas producers won that battle between adjoining landowners by requiring the payments to people in the same pool, the pooling efforts. While that may be an excellent solution for a finite oil and gas resource, it's not a good solution for groundwater. The surface estate still has economically viable uses long after the oil and gas has been captured and removed. The same cannot be said of groundwater. As you pointed out, Mr. Chairman, you cannot drink oil. We have to have water to survive. By the way, last night in Bastrop, we heard a hearing on the recent application by Lower Colorado River Authority for a 25,000 acre foot permit. And one of the things I heard was a discussion about how if you don't have air, that it's over. If you don't have air and water, you can only survive for a few, measly hours, a few days. If you don't have air and water and food, you can survive for about a month. Or if you have air and water but no food, you can survive for about a month. And if you don't have water, you can't get the food. So water is really tied into our future survival. It's absolutely critical. The usability of a surface estate and the economically viable use of that surface estate is tied directly to having some sort of water supply for use on that property. I cannot think of a single economically viable use, except perhaps oil and gas exploration, which, by the way, needs some water to be able to drill those wells to begin with, if you don't have a water supply available to that property. If neighboring wells actually lower water levels below the level where your well can produce, the rule of capture prevents any recovery against that neighbor. Your only remedy is to pay to drill a new and deeper well, if that's even possible. Where it isn't possible, the overlying surface estate may be left barren and useless. In my opinion, groundwater conservation districts are created for the express purpose of preventing the harms otherwise allowed by the rule of capture, and by doing so, protecting private property rights of every landowner. Districts are attempting to achieve that goal by protecting historic use, by setting production limits based on specific aquifer conditions, and tailoring their regulation to address the unique conditions of their aquifers and the unique needs of the various regulated communities. Now to the legal problems. There's several issues with the possible takings claims that I'd like to address. First off, who's in the best position to make a taking claim? The permit applicant who's either denied or limited in how much groundwater may be withdrawn, an adjacent landowner whose well is damaged because a district issued a permit and that production is lowering aquifer levels, or a landowner who doesn't own a well but intended to drill one at some point in the future and is watching as his neighboring permitted operations are lowering aquifer levels. Takings jurisprudence protects investment-backed expectations. And the Bragg case the Bragg case tells us we must compare the value of the property prior to the regulation and the value of that same property after the regulation is in place. That seems to heavily favor anyone with historic use. But the Supreme Court said in Day, no landowner may be denied all access to their groundwater just because they don't have historic use. So what do? From the district viewpoint, a district that denies a permit may be sued for a taking, but if that same district grants that permit and either neighboring wells or landowners are damaged, the district may again be sued for a taking. Although the Day case has been heralded as a victory for private property rights, instead it has greatly complicated protection of those private property rights through regulation. The only successful takings claim, the Bragg's Pecan Farm case, the award was not based on the Braggs receiving their fair share or the amount of groundwater beneath their property or even their historic use. The award is based entirely on the value of their land as a pecan farm and the eventual need for much more water than the statute would have allowed them to have. On one farm, they were issued a permit equal to the amount given to every other irrigator, but the damages were still awarded. That means districts can be held liable to landowners based on how they intend to use the groundwater in the future, where those intentions are backed by investments. And landowners who have never drilled a well or simply can't prove through their investments how they intended to use their land and groundwater will likely be unable to receive any compensation if their land is dewatered by overproducing the aquifer. Until we have that lawsuit, though, we really don't know the answer to that question. Legislation designed to require compensation to be paid would allow entities with deep pockets to take water from their neighbors and simply write them a check. Indeed, that is exactly how we resolve the issue with oil and gas. But most landowners want water, not money. Secondly, a law that requires mitigation but doesn't allow districts to limit pumping to an amount that wouldn't result in the harm occurring in the first place is really no different than eminent domain. You're telling the landowner, we're taking your water, here's a check. In my opinion, groundwater conservation districts should not be in the business of condemning one landowner's water rights in exchange for compensation from another landowner. Instead, aquifers should be managed to allow the maximum amount of production that will not result in damaging any landowner's property rights. In my opinion, if a statute requires a district to take certain action, either granting or denying certain permits, then the state, and not the taxpayers and ratepayers within the district, should be responsible for paying any sort of takings claim. One of the great injustices in my mind is that the Bragg Pecan Farms and their $4.5 million verdict against the Edwards Aquifer Authority was paid by the ratepayers to the Edwards Aquifer Authority when that authority had absolutely no choice in how those permits were issued and how that permit was denied. The statute required them to take the action they did, and as Brian pointed out, after you wrote that law, after the fact, the courts came in and decided whether or not we did a good enough job and whether or not that resulted in the takings. In that instance, they said, yes, it did, and it cost all the ratepayers in the Edwards Aquifer region $4.5 million. Representative Burns, as you said, this is a very complex issue. My recommendation is that we let groundwater conservation districts continue to deal with those issues, and we're just going to have to suffer through many more years of litigation to settle these questions. Where possible and necessary, legislation aimed at a particular problem in a particular district may be addressed through local bills without causing problems for the rest of the districts that either don't have the same issues or having caused the same problems. By the way, I wanted to let you know that the Attorney General issued an opinion yesterday making it clear that historic use permits do not represent permanent water rights that can be used for any beneficial purpose. Instead, any attempt to amend either the amount of the permit or the purpose of use must be handled exactly the same way an application for a new permit would be handled. A lot of people think their historic use permits are a permanent water right, and they simply are not. Districts have the ability to reduce historic use permits the same as they do any other type of permit, but every step that we take potentially leads to somebody being able to file a takings claim against us. Right now, today, we have two different lawsuits in play. One is an adjacent landowner who is suing the district for issuing a permit, and one is from the landowners who are suing the district for not giving them the party status in a contest to challenge a permit. They're from opposite ends of the spectrum, by the way, the people backing those lawsuits. One's an environmental group and one's a landowner group, and it's the poor districts that end up stuck in the middle. With that, I'll be happy to answer any questions.
Anybody have any questions for Mr. Ellis? Thank you.
Thank you.
Thank you very much. Greg Singelman?
My name is Greg Singelman, and I'm the General Manager of the Gonzales County Underground Water Conservation District.
Yeah, you might need to pull that mic closer to you.
Okay. That better?
Yes.
Okay. Greg Singelman, my name is Greg Singelman. I'm the General Manager of the Gonzales County Underground Water Conservation District, and I'm here to talk to you today about Interim Charge 3D, the appropriate consideration of service area of a water supplier when groundwater resources are allocated based on surface ownership. Okay, so the Gonzales Underground Water District rules allow a public water utility to claim acreage within their CCN or service area under the following conditions. Okay, so the utility's well should be located within the CCN or their service area. Also, the well has to follow any and all permit conditions as any other permitted well. Spacing, everything else, they've got to follow the same conditions. Any property with permitted wells within the CCN or their service area, plus all leased or sold water rights within the claimed acreage are deducted from their claimed acreage. Okay? And so every time the permit comes up for renewal, those acreages and those permitted rights, sold or leased water rights, have to be recalculated, and then those permits are adjusted. And our permits are 5-year permits, so each time those permits come up for renewal. Any other permitted wells in those areas or any other leased or sold rights would come out of that acreage claim for their CCN, okay? So we feel that consideration of the service area of a water supplier allows the water supplier access to the landowner's groundwater, and in return, the water supplier provides a reasonable cost, high-quality water supply back to the landowners within that service area. Under the district's current rules, a landowner may opt out of this arrangement at any time and obtain a permit for his own personal use or lease or sell his water rights to another entity. So it seems to work real well for us, and we're a district that has a lot of leased and sold water rights, yet the CCN acreage still can cover the needs of our rural water supply utilities.
Anybody have any questions, Greg? That's interesting how y'all redistribute after five years when the permits come back in.
It's a large calculation because, like I said, like Saws, all these big well fields, they've actually leased more land than they have water permits for, but that water is leased away, so we take that out of the CCNs also, even though they're not using that. Those are leased water rights out of there, and they have control of those water rights.
Thank you very much for coming down. Cheryl Lynn Dahlberg. Yeah, if you'd use that other mic. Yeah, there you go. Thank you.
Is it on? Is it on? It is.
Yes.
Good afternoon. Thank you for allowing me to speak with you this afternoon and explain our position on the Senate Bill 573. Appreciate Representative Lucio and his support for our area. Appreciate Representative Larson that you're holding this hearing in our area today. My name's Sherilyn Dahlberg. I'm General Manager at Sherryland Water Supply Corporation. We have all of our water system inside the County of Hidalgo. We have $20 million in USDA debt. We have a certified area of 120 square miles, and all of that in Hidalgo County with 1,000 miles of water lines. We have 3 water plants that can produce 22 million gallons a day, and they are strategically placed across our system to be sure that all of our system can be adequately served. We have 18,500 customers and more than 60,000 people that are receiving service from us daily. We're adding new customers every day. Development in our system is growing and thriving. We have 48 employees, and we conduct our business with deliberate decision-making. We take our responsibilities very seriously. Our focus is to continually maintain and upgrade our infrastructure, review and assess the results of our decisions and our work product, and control expenses, but also to spend the revenues to improve the system to the benefit of the current and future customers. All of these things contribute to our success. When this bill was passed, it was intended to take care of bad actors in the state that were not working cooperatively to the benefit of growth for the communities. We understood that. Unfortunately, since it has passed, it seems to have morphed into something that it was not intended to be, at least in some parts of the state. I'll give you an example. There is a 2,600 acre property inside our certified area, which for decades and decades has been used for agriculture, growing crops. In recent years, the developer owner of that land came in and said he planned to develop the property, told us what he was going to do. He was going to build it out to about 8,000 water meter accounts, over a period of time. We told him we could take care of everything he needed immediately. There would be no delay. It wouldn't cost him anything. We had all the infrastructure in place. He asked for fire protection. We said, yes, we'll give you that. He asked for a certain kind of billing situation. We said, yes, we'll give you that. Everything he asked for, we provided unconditionally in our discussions. And we could do it immediately. To expand on just how capable we were to handle it at that point in time, we had an 8 million gallon a day water plant 1/2 mile away from this entire property. We had 16-inch water lines on all sides of this property. And we told him we could provide it to him right then. He came back and said, the city wants to serve me and I'm going to let them. And of course, he's in our CCN, so I told him we would be serving him. A little later, I learned that the city was working with him to find a way to push us out so that he could receive service from them. And in fact, the city told me directly that the city wants what the city wants, and they intended to take that property. Fortunately for us, this story has a good outcome. They could not, because we're not in one of the counties that has 1 million in population yet. But we do believe we'll be there at the next census. So in the end, we served the property and there were no hitches. And the city did back off and the developer relented, and it's all worked out. And in fact, the newest university in the Rio Grande Valley went online this fall just as it was supposed to. My point is simple. When you're the 5th largest water system, rural water system, water supply corporation in the state of Texas, and you are doing everything that is required of you by the lending agency and expected by the public, when you work cooperatively with your neighboring cities, when you've been totally responsible, it's unreasonable to provide water, to punish water systems such as ours by lumping us into the same category as those systems who cannot accomplish the same needs of developers and those who would grow the area. A reasonable, proper solution would be to exempt large systems like ours, maybe 7,000 to 10,000 or more in customer accounts. But even then, smaller systems should be given their due process, which this law seems to not do well. If the law was built to protect the public, then please consider that customers of responsible water systems should not be punished when the system will and can provide the developer's needs. This is a large state, and to penalize water supply corporations who do their job well would be punitive to hundreds of thousands of Texans, as they would have to compensate for the revenues lost to another provider. Bad actors and those not acting in good faith otherwise take advantage of the process, and the only loser is the CCN holder and its ratepayers. Thank you for listening. I appreciate that you've come down here to help us find solutions to this legislation.
Yeah, Representative Frank has got a question for us.
Why did the developer want to go with the city instead of your organization?
Well, I took it out of my notes, but the simple answer is the city was trying to make a deal, and they wanted the development to be included in their city's accounts, and they wanted that university in there, under their name.
So was there any rate differential between what y'all charge versus what the city charged from a water standpoint?
There is a little rate differential, but our rates are right in the low to middle of what most rates are across the Rio Grande Valley for rural drinking water, or, excuse me, retail drinking water.
Okay, thank you.
You're welcome.
Thank you, Sherilyn. Appreciate you coming. Michael Taylor.
Good afternoon. Thank you, Chairman Larson and committee members. I appreciate the opportunity to speak with you all. I'm speaking about interim charge number 6, and I'd like to share my experience as a water supply corporation that has converted to a SUD. And we've experienced the downsides of expedited decertification process created under Senate Bill 573. We were created in the 83rd legislature to be a SUD. We were a nonprofit for 50 years prior to being reorganized as a SUD, and right now we're growing, and we have about 6,000 customers. As a holder of a statewide, state-granted water and sewer certificate of convenience and necessity, Crystal Clear has a duty and an obligation to provide continuous and adequate service to all our customers within our CCN. We take our duty seriously. In order to provide this service, we've made significant investments. We own water in the Edwards Aquifer San Antonio pool, in the Uvalde pool. We own water in the San Marcos River. We lease water from the GBRA in the Guadalupe River. We participate with Canyon Regional Water Authority for Wells Ranch underground water, and I'm on the board of the Alliance Regional Water Authority, and we're getting groundwater for that organization also. So we have a significant investment in water resources to supply our customers. We've long adhered to our end of the regulatory compact, and in return for the statutory duty to serve all our customers in our CCN, and that CCN area is protected from encroachment. This protection is crucial to allowing rural water utilities to plan and invest in needed infrastructure for the entire CCN area. As you can see from my written testimony, we believe that the Public Utility Commission interpretation and application of Senate Bill 573 and related water code decertification provisions has disrupted this compact. Neighboring cities, usually working with developers, are cherry picking the high growth areas of water supply corporations and SUDs, which incumbent rural water providers we're not receiving any compensation for it. Their interpretations don't call for that. We believe that if we have an obligation to serve, then we make the investments, and we should not be cherry-picked and allow people to just wholesale leave our systems and leave us holding the bag. We believe that the expedited release and related decertification provisions mandate just and adequate compensation, and the interpretation of useless or valueless is not being done properly. We're not getting compensated when they do decertify. We're spending hundreds of thousands of dollars defending our territories, first in the state courts. The state courts have never ruled in our favor. and then we go to federal court, and then we get a favorable ruling, and we're still out the money because we're just defending our territory and trying to do our job. The lack of recourse in state courts as a result of this, Crystal Clear and other large, capable rural water providers have been forced to resort to federal court to defend their investments in service territory. Crystal Clear has recently obtained a favorable decision in federal court, but that decision is not final. I don't have the Attorney General to continue to fight me all the way to the U.S. Supreme Court. They do. So it's an unfair fight. Requiring nonprofit rural water providers to defend our water rights for our entire CCN in court requires significant expenditures over several years that can ultimately leave us cash poor. And rural water providers are simply forced to accept, in many cases, these land grabs because the alternative would be to divert resources that are essential to planning and maintaining their systems consistent with their statutory duty to provide continuous and adequate service. In short, we were not and never would be one of the bad actors. We step up. We want to provide service to everybody that comes through our door. We work with responsible developers. We do everything we can to bring those customers online. We don't tax. So it's to our benefit to get water customers, get those meters out there, start selling water. But we have had several developers come in and say, I'll just go to the city. It's just easier to go through the city. They're going to do my platting anyway. I've got to meet their codes and stuff because I'm in their ETJ. And so they feel like they're at a disadvantage and they might as well go to the city in the first place and bypass us. And this law just gives them carte blanche to say, and this actually happened to us, turn my meters off. I don't want your meters on my land anymore. So we go turn them off, pull the meters as requested by the landowner. Then they file their petition and say, I'm not being served. And their own exhibit in court shows a water line going up in the middle of their property. And under cross-examination, my attorney asked him, what is this on your exhibit? It's a water line. Whose water line is it? Crystal Clear's. Well, what's it for? We don't know. There's no meter there. They had the meter pulled out. We were serving them. It is totally unfair to say, I'm not being served because I had the meter pulled out, and now I'm going to pull this whole service area out of your CCN, and you're never going to sell water there and never going to have any benefit from it. When we went out and spent $7 million for Edwards Water to serve areas in that area. Not specifically, but we are going to serve that area. And we have made the investment to provide water to that area. So, in short, we feel like we have not been a bad actor, but we've been the victim of some bad actors, and we think you all can fix that.
Thank you, Michael. I mean, the great description of the problem Senator Lucio and I said on the Natural Resource Committee when 573 came through. There were some bad actors, some people that couldn't deliver, the Tyler and some of the other issues that have come up today. Reality is some people are abusing, what we passed, and I don't know how we reconcile it. We let our intentions were good. Absolutely. As far as trying to get, property that wasn't being served. And then also utilities, some of the utilities were hijacking the developers, saying you got to do this, and there was other options on the table. You're right. So there was a balancing act, but there was also a contemplation, and we had come back and address any of the shortcomings of the bill, and I think that's why Representative Lucio has pushed forward last session, and I would assume this next session to address some of those. We got an uphill battle, though. So we're just going to have to try to negotiate the best we can to try to reconcile some of the problems you've addressed.
We firmly believe that you had every good intention of dealing with bad actors in this bill. Absolutely. We believe we were an unintended consequence of bad actors on the other side of the coin, and we believe that you will go back and fix it for us.
Thank you, Michael. Appreciate it. Pat Allen?
Good afternoon, Chairman Larson and House members. I appreciate the opportunity. I'm not as slick as some of these other guys. I'm not a seasoned speaker, so bear with me here. I'll try to get through my story, but I'm here to talk about Senate Bill 573. My name is Pat Allen. I am the General Manager of Green Valley Special Utility District. Green Valley serves portions of extraterritorial jurisdictions and some portions of city limits of several cities and towns around me, including New Braunfels, Seguin, Schertz, Cibolo, Marion, Santa Clara, New Berlin, and St. Hedwig. Some of these are small, some of these are larger. It's a very high growth area. Currently we're serving just under 13,000 connections, about 12,800, and I expect to surpass 13,000 by the end of this year. We're setting about 600 to 700 meters a year. That's water services. I became manager in 2007. I've been there for 21 years, but the last 11 years I've been the manager. In 2007, I was faced with a large service area with a small amount of water resources and a service policy that made it very difficult for any developer to come in and develop. Our thinking was we didn't want growth, we didn't want this to happen, and so we were a prime example of a bad player. I realized that, and I didn't think that was the right way to be, because our statute says we are to provide service for our service area, our CCN, and we were not doing that. Working with my board of directors, my engineers, our attorneys, we slowly started turning things around, and to this day, I've probably tripled or quadrupled our water resources. We are providing service, we're providing fire flows. Like I said, we're setting 600 to 700 meters a year. So we are now doing our jobs. Most recently, I received a wastewater permit because I also have a wastewater CCN. It did take 2 years. I did have quite a few contested case hearings because a couple of cities are wanting to take over my wastewater service area. And so they protested my permit, but I did prevail. I just received it, and we hope to begin construction within a year. I also belong to 2 regional water supplies through Canyon Regional Water Authority, just like Mr. Taylor just left. The Canyon Regional Water Supply and our Wells Ranch, and Alliance Regional Water, which is, Alliance is a group that actually is, and one good example of this is that Alliance represents the city of San Marcos, city of Kyle, Buda, Crystal Clear, Sud, County Line, Sud, Green Valley. We all work together to form this regional project. And bringing water into my service area as well as Mike's and those cities mentioned from over 40 miles away. Our Wells Ranch project does the same thing. So we have done our jobs. We're working very hard. However, I am fighting decertifications in my sewer service area in a manner where the cities are working with the developers, trying to convince them to decertify, especially because they control the plats and their plans, and makes it difficult. They're cherry picking my sewer service area. I've gone through the route through the PUC and have had litigation for 4 years now. I didn't do too well at the PUC. I didn't do too well in the state courts. I do have federal debt, so now I'm fighting this in the federal courts. Senate Bill 573, I understand the reasoning behind it, because not all systems are created equal. Some of us are doing our jobs, and some of us are just kind of are looking the other way. So I understand there are those properties, there are those locations that need to be decertified, because the developer needs to be able to develop. But there are other entities like Green Valley, Sherilyn Sudd, crystal clear. My compadres behind me that are doing our jobs, and it's not fair for us to be decertified that easily. I do think there needs to be more of a review process, maybe through the PUC or some other way to say, hey, fellas, what's going on? Let's sit down and talk about this. What can you do for me and at what cost? That's how I conduct our business in Green Valley. I have developers coming to me all the time now, especially since I've got my sewer permit, knowing I can provide both services. And even though it's 2-3 years out before I'll have that ready, they're ready to wait for that. They're saying, we have tracts of land we're interested in. Let us know how you're doing. We may even help finance some of the process you're going through on your treatment facility. So I'm looking forward to that. However, I'm still concerned about the encroachment and the decertifications that's happening in my service area. We've worked very hard, and I've committed to millions of dollars on 30 and 40 years out on paying for these water projects. So I need development to happen. I need the rooftops. I can't pay the bills without that. And that pretty much completes my testimony. If you have any questions, I'm more than happy to answer.
Do you have any questions for Pat? I mean, very similar to Michael, where you're expanding, you're on the, in the I-35 corridor right there. And
right.
Y'all both have the same issue. Then you have developers coming in and their cities are growing, and y'all are trying to balance your needs. So appreciate you coming down here.
Thank you very much. Appreciate your time, sir.
Melissa Rich. One more. There she is.
Hi, I'm Melissa Rich. I'm with Blackland Water Supply Corporation. We're located in Rockwall County. We service Rockwall County and part of Hunt County. My location's a little bit unique in that I have 3 different municipalities that are encroaching upon me, and all of them, are experiencing a lot of rapid growth. One of the areas has a 4,000-acre development that
Yeah, can you use that other mic, because they can't hear you behind you? Yeah, that's cool.
Okay, one of the developments within my CCN area has a 4,000-acre tract of land that developers are interested in developing. And once they decided that they were going to develop this, they took it over to the city that had this area in their ETJ, and that particular city decided that they did not want this development to happen. So then, of course, the developers went over to the bigger city within this area, which would be Rockwall, and presented their idea. The developers then began talking with Rockwall about what they could do. Rockwall has told them that they're going to have to spend millions of dollars to run water lines out to this area when I already have existing lines right there. They're trying to convince these developers to decertify this property, and it's not about the service, but it's really about the money. And so they have kind of put some different demands upon these developers that if they don't decertify it, then they'll either not approve the plat or they will annex the area.
That's interesting. He said that was Rockwall?
Yes. And the whole thing is that they're not in, as it stands right now, it's farmland. And they're not interested in taking it right now. They just want, if it wasn't going to be developed, they wouldn't even be interested in it. They're kind of using these strong-arm tactics to get these developers to do what they want, when really it should be the landowner's choice or the developer's choice. And they shouldn't be forced into making decisions like that based on what the municipality wants. Currently, there's nothing really in place that's forcing these developers to even come to me to see what my capabilities are as far as providing water to them. That makes it really unfair, not just for me as the CCN holder, but it's unfair to the landowner to have those stipulations placed upon them, and then ultimately it's unfair to the end customer that ends up either our existing customers or customers that end up living in this new development. At present, the municipalities can just tell them whatever they want. They're not forced to bring me to the table. And so that's one of the things that I think needs to be changed, in that, when a development comes into play, they should be required to at least explore what the CCN holder is able to do. And they should be able to come and see if we are able to adequately provide for that development before they are able to decertify it. A lot of times we're not aware of it until we get that phone call that they're considering decertification. And so I really think that it's disadvantage. We're at a true disadvantage of it, and we're not able to adequately, stand our ground, and we're going to end up having to fight it through litigation instead of, in the beginning when everything's being planned out. So I'm just asking that you guys would maybe consider, some of these issues in the way that the municipalities are dealing with water supply corporations such as myself.
It's a tough issue. Like we said before, I don't know how we reconcile it. I mean, from the standpoint, we've got a bill that it accelerated the decertification. You got people with the expectations now, especially in those 32 counties, that they can go in and shop it. Now you have the cities and that issue about them, trying to expand their horizon and having so. I mean, the urbanization, there's a lot of complications. We see it with emergency service districts. Mm-hmm. We see it with the water supply corporations, and the contemplation of growth. It's accelerated in a lot of these areas, and it's sort of jumping over boundaries and growth trends and the rest of it. And so it's sort of it's a mess, to be honest with you. And some of the developers are taking advantage of getting a better deal, and trying to figure it out. So I don't know. I mean, I've got it in my area, but most of the area I have is already developed out. We had an issue with Bear Met, and San Antonio Water System ultimately took it over. But in these fast-growing areas, this is one of the complications. So we'll have to just see how it works. I think primarily talking to Laura and trying to figure it out is on the compensation side, if this does take place, right. And trying to figure out a formula on how we can have folks adequately compensated if that area is taken away. And it would be basically a pretty basic, infrastructure that was developed out or stubbed out to that point that would have never been stubbed out without understanding that property was coming into your area, or it was right. in your area. So, right. But we appreciate you coming all the way down from North Texas.
Thank you.
All right, thank you. Our last person to testify would be Morgan Johnson. Yeah, go ahead, Morgan.
Good afternoon. For the record, again, my name is Morgan Johnson. I'm an attorney in Austin, Texas, at the law firm of McGinnis, Lockridge, and Kilgore. And today I'm here now speaking on behalf of a client, Maxwell Water Supply Corporation. Maxwell Water Supply Corporation provides retail water service to an area that stretches from a little bit west of I-35 down to San Marcos and east towards Lockhart. And since we've covered a lot of testimony about this topic already regarding SB 573, I'm really going to hit the high notes and just discuss what occurred to Maxwell. And this was in 2013 before the transition over to PUC, so it's a TCEQ decertification, but the facts nonetheless are, I think, some of the unintended consequences of the Senate bill. In 2013, a developer filed a petition with TCEQ pursuant to the streamlined expedited release process that requested approximately 216 acres be decertified from Maxwell service area. Once Maxwell received the petition, Maxwell filed a response with the TCEQ requesting that TCEQ deny it. However, despite Maxwell's timely and thorough explanation, TCEQ granted the petition. Maxwell then filed a motion to overturn the order, but it was also denied. Maxwell subsequently appealed the TCEQ order to the Travis County District Court. While there, the parties eventually were able to settle the disagreement in a settlement agreement outside of court. And the facts of the case that I would just like to highlight for you today would be that first, like many have said before, Maxwell did not know about this developer and their request or need for water service in the area. At the time the petition was filed, Maxwell would have been able to basically install a tap and meter for a residential water line within 5 days. Furthermore, at that time, Maxwell's general manager was never aware and could not remember any time that they had ever denied someone service that had actually come in and talked to him about it. And as a water supply corporation, they have a CCN. Thereby, they're obligated to serve those people within their service area. And following along those lines, by the time the developer had actually filed the petition with TCEQ, Maxwell had already spent a considerable amount of time and invested substantial resources in planning to serve its service area, which included the property in question. For example, Maxwell had constructed and had in the ground a 12-inch water line and an 8-inch water line that either ran up to the property or across the property in question. Their system also had included a 500,000-gallon elevated storage tank that was in a 2-mile vicinity of the property and was constructed with the intent to assist in serving this piece of land. Furthermore, Maxwell had acquired a surplus amount of water in anticipation of providing service to this property. Therefore, just because of the fact that Maxwell didn't have a meter on the property and wasn't turn ready did not mean that Maxwell had not invested substantial resources in attempting to serve this property. And I was actually discussing with the general manager in the back the issue that municipal question had arisen during this testimony to see if there was a difference in rates or if it would have been cheaper for the developer to go to the city of San Marcos rather than come to Maxwell. And from what they were told by the developer during settlement discussions is that they had never considered coming to Maxwell for water service and assumed Maxwell did not have the adequate service for the high-density residential development they were going to put into the property. That's all I have for you.
Same story.
Yeah,
exactly. You know, so I don't know. I know we've got a working group and definitely want everybody's interest here expressed there in trying to figure out and where the middle ground is. You know, we've got Trey Larry and some of the other folks trying to help us navigate back to where there's a sort of a reasonable growth pattern. So thank you, Morgan, for coming.
Sir. Thank you.
Guess we have no one else to testify. I think everybody in this room's testified, except maybe y'all and Isaac, you know, so. But I appreciate everybody coming down here. I appreciate Representative Lucio's invitation and hosting us, the city of Brownsville for accommodating us with this facility, and Carolyn and Shannon for putting everything together and making this trip special. So, members, y'all have anything? Okay. Well, Chair hears no matters to be discussed. The Committee on Natural Resources stands adjourned.